to mention a matter, my lord, under compelling circumstances, my lord, that is 101 of today's list, my lord. My lord, this is, my lord, your lordships may kindly remember, my lord, this relates to one of the matters which your lordships is hearing, my lord, where, my lord, I have filed an application for addition of party. That is fixed on, my lord, 31st, my lord. My lord, some of the riots, my lord, who are also the recorded owners, my lord, they have come up before the lordship, my lord, by filing this heat application, my lord. My lord, this, my lord, total area of bill, my lord, that is water body, my lord, relates to, my lord, 504, my lord. But out of that, my lord, 200 have already been vested to the government of West Bengal. And out of that, my lord, 119 acres of land has been, my lord, leased out in favor of one of the parties who have come up before this honorable court by filing a writ petition, my lord. This petition is being heard, my lord. Now, what has happened, my lord? Taking advantage of that, my lord, in connivance of the police, my lord, for the whole, my lord, out of, my lord, 504, my lord, 119 they can, my lord, enjoy, my lord. But the police is helping, my lords, others, my lord, IOs, being the one of being some owners, my lord, before the lords is, my lord, they cannot, my lord, fish there. They cannot take any advantage, my lord. Whole the, my lord, the water body is being enjoyed by the private person in connivance with the police, my lord. The police has taken active part, my lord. Last, my lord, they have suo moto, my lord, registered FIR against the some of the recorded owners, my lord. So kindly, my lord, subject to lordship's convenience, my lord, the application for addition of party in connection with those two applications, those have been fixed on 31st, my lord. Lordship may kind enough, my lord, to, my lord, fix it, my lord, subject to lordship's convenience. These each application, my lord, on the 31st, my lord.
Okay.
My lord, I am keeping this, my lord. I have served notice, my lord.
May I permitted to mention, my lord, one upgradation, my lord. The petitioner is aged about 89 years, my lord. He is a scheduled caste community. He want to sell his property, my lord.
Needs permission.
My
Yes, give the number.
my lord, may I extension of interim order for
Give the number.
31st.
My lord, extension of interim order
Give
for
the number.
31st, my lord.
Contempt application.
Extension of interim.
ওটা to be mentioned রাখুন for release. For release.
Extension of interim order at the 31st.
Your lordship, may I be permitted to mention matter?
Extension of interim order.
So many extension of interim order.
May I
Give the number. Give the number.
Your lordship, may I be permitted to
Restoration.
mention?
Give the number.
This is motion matter of 2023. This was filed in the month of April. But during a vacation period, they are trying to raise the construction.
Give the number.
May I permitted to mention?
Contempt application. Give the number.
May I permitted to mention, your lordship, for upgradation item number 858, the private respondents are undertake unauthorized construction of multi-story numbers.
may I permitted to mention, my lord, this matter is unauthorized construction, my lord. It was taken up for hearing on 12th July. And your lordship directed the matter would be listed on 4th of August. Thereafter, it was listed, but it was in the monthly list, my lord. I am praying for some
Give the
application.
number.
May I will kindly to mention, my lord, for
Grateful,
inclusion in the list two application, my lord. One is vacating of interim order, and another is the for added party, my lord.
Addition of party.
Addition of
You want
party,
to be
one-
added as a
Yes,
party.
yes.
Give only the addition of party application first. If you are added, then only you can pray for a vacating, isn't it?
Yes.
The addition of party to application.
And I have a lordship kind of matter. Some urgency I have not with regard to there is a direction upon the DLRO, which is clearly in the daily listeners. There is a direction upon the DLRO to inspect the property, and with regard to the my ROR, when they are not inspect the
Daily list matters, please do not mention, sir. I'll consider. I'll take up.
with regard to some,
I'll take up the matter.
with regard to some monthly list matter, my lord. Second round of list.
It is in the supplementary list, the daily list.
No, not daily list, my lord. I have mentioned, my lord, rejected, but this is from the supplementary monthly list.
It's in the monthly list. Give the number.
Lordship, may I be permitted to mention a matter? Lordship, as per your order, the matter was supposed to appear today. It was fixed as 3:30. Mr. Dotto was making his submissions. However, the matter is not appearing today. In the meantime, your lordship, the interim order is expiring on 31st. May the matter be kept as to be mentioned tomorrow? 1829.
My lord, for inclusion, my lord. For inclusion.
What is your urgency?
Urgency, the matter was filed on 21st March.
Maybe. Yes.
The private respondent blocked the full road, my path.
Give the number.
My lord, may I have a lordship and matter extreme urgent, my lord. the private respondent making construction in front of my land, encroaching the government land. There is no pathway.
Give it name.
My lord,
The 10 residents of and for the purpose of the trash and collection. But when came approach to the authority for the compensation, it has been found that then has not been agreed as much as. So my humble submission to provide the and share information regarding. Simple matter.
Give the number, let me see. Yes. Oh, acha, acha. You are appearing in this matter.
For the petitioners.
It's a group 1 hearing matter.
Lordship, it was running in the list as group 1 motion on the last occasion.
List check করুন। In that case, it will appear tomorrow. If it's
Very
a group
well.
1 hearing, it will appear tomorrow at 3:30.
3:30, very well, Lordship. Much obliged to you.
Yes, call the days list, please.
item number 1. I don't know, 1 where? No, 1 I'm 2.
Item
But if
number
the
1,
interim order is expiring, I am for the petitioner, my lord, it is expiring on 31st May. August, my lord. My lord, the
I submit my lord that
affidavits are complete. But
since long, my lord, time to time it has been extended and lordship was
My lord.
pleased to direct the matter be placed, my lord, for hearing,
My
to be on hearing. But all that I'm submitting, my lord, according to us is a short matter. If your lordship, my lord, gives some precedence, but it could be, my lord, complete, I understand, my lord.
let it be extended for some
But then, yes, yes,
time.
I'm just now I'm not objecting, but your lordship, my lord, make it clear that so that the matter could be, since long, my lord, is continuing.
I know hearing matters are pending.
affidavits are complete, my lord.
And my lord, some precedence be given, so that, my lord.
Let's see. Affidavits are exchanged. Paragraph, let the matter appear under the heading group 1 hearing on,
But it was in the list, my lord, for hearing. Your lordship let it retain in the list, my lord.
it will, 20th September. Paragraph, the interim order granted earlier is extended till 30th September or until further orders.
My lord, I'm
Whatever is
just
earlier.
requesting your lordship, my lord, instead of placing the matter 20th September, earlier to that, your lordship place it, my lord, so that, my lord, if it could be possible, my lord, to take up the matter. Yeah, first week of September, your lordship
Very well,
place it,
13th September,
my lord.
13th করুন, huh? There is a direction upon the officer in charge also, I think, isn't it?
But
The
that, my lord,
orders.
continuing.
Paragraph, the officer in charge, comma, Pragati Maidan Police Station, comma, being the 7th respondent herein, comma, is directed to ensure strict compliance of the interim order by both the parties.
I'm deeply
Actually, my lord, our contested the land belongs to us, my lord. That is the difficulties, my lord, we are facing.
But they could not show a single piece of document that showing that there is an
It will be
acquisition.
heard. It will
That is the
be-
merits of the
hear it out.
matter.
Item number 2.
Well, I am appearing on behalf of petitioner. This matter has come under the heading to be mentioned for correction of the
Yes,
order.
what's the correction
No,
required?
well, I have handed over, my lord. Marked in, my lord. My lord, the letter. My lord, kindly see, my lord. Second para, second line, my lord, it will be
Oh, here
February-
you have given one correction.
February 2, 2022, my lord.
Have you put the other side on notice?
Yes, my lord. I have
Who is appearing?
submitted, my lord. This is the notice.
Respondents?
Yes, my
Your
lord.
appeal-
Yes. My lord, second para, second line, my lord, it will be 2nd February 2022. Thereafter, my lord, third para, third line, my lord, section 8, it will be section 8, my lord, instead of section 18. Fourth para, fifth mile, it will be 24th June
2002.
2002, my lord. This is the correction.
Yes, these corrections we made.
Yes, my lord. These are merely dates, my lord.
May record.
The matter has come up under the heading to be mentioned at the instance of the, you are the petitioner.
Yes, my lord. Petition number 2
Petitioners.
and respondent number 5 to
Paragraph
11.
inadvertent error has crept into the order passed on 24th August 2023. Paragraph
Second
in
para,
the-
second line.
second paragraph of the first page of the order. February 02, 2023 be read as February 02, 2022. Stop. Paragraph in the second paragraph of the second page of the order, section 18 of the Act of 1948 be read as section 8 of the Act of 1948. Paragraph in paragraph 3 or in the third paragraph of the second page of the order, comma, June 24, 2022 be read as June 24, 2002. 2002. Paragraph, the department is directed to incorporate necessary corrections accordingly. Paragraph, this order be treated as part of the order passed on 24th August 2023. Paragraph, urgency 5 website copy.
Yes. My notice be kept on record, my lord. I have some notice be kept.
Item number 4. They come for extension of interim order. I have already served notices to the respective.
Where is your notice?
Union of India.
The service.
My lord, Nilanjan Bhattacharya is appearing on behalf of the Union of India, my lord. My lord, kindly fix it up any day on for hearing.
The order has expired on 15 July. So after that, there is no extension. There is no interim order to be extended at the moment.
Kindly extend the.
How? The order should be there for an extension.
Well, I understand, my lord, there's some mistake on my part. We thought August, my lord. Kindly extend it.
You have to file an application.
But there is in appellate side.
Cannot be suo motu extended without an
In
application.
appellate side, my lord. I mean, my
File an
mistake.
application.
No.
I cannot, the order is not there for extension, sir. I'm sorry. You have to file an application for consideration. For interim order. 15 July, we are on today's 29th August.
What happened in the meantime? My lord was not there for 2 weeks. Kindly.
Interim orders are extended by any court. Please
I understand.
submissions.
Okay, I understand, my lord. Kindly extend, my lord, for the first.
Cannot be done. You have to file an application. No order need be passed. Next.
No order passed. No order need be passed.
Item number 5.
What is the contempt matter? This was taken up yesterday also. I am filing my affidavit of complaint.
Applicant,
The petitioner was here on the last detail. Yesterday she was here, madam. An order was directed to be passed that has been.
final order has been communicated.
Come.
Who is the petitioner? Would have been disposed. You have served a copy?
I am not served, nor I will serve within the course of the day.
Let there be a date.
My lord, they are not even, my lord, kindly, this matter, my lord, I am.
I'll give you a very short date because in absence of the petitioner, I cannot dispose of.
No, she
You
was
have not
here
served a copy
yesterday.
also.
Yesterday she was
I
here.
know she was here yesterday, but today she's not there. And you have not served a copy also, isn't it?
My
None appears for the applicants / petitioners. Paragraph affidavit of compliance submitted on behalf of the alleged contender is taken on record. Paragraph, let the matter appear under the same heading on. Will you come back on Friday? Will you inform her? 1st September.
Six.
My lord, I am for the petitioner. My lord, there are 5 applications.
Have you served?
My lord, the service is not complete. My lord,
Serve
kindly
and
allows me some days to serve.
Good. Since service is not complete, comma, Let the matter stand over till 14 September? 14 September. Huh?
কোন দিকে দাদা?
Grateful, madam.
কোন দিকে যেখানে খুশি পাঠিয়ে দাও।
I beg to appear on behalf of the petitioner, my lord. Now, this matter relates to, my lord, extension of the lease deed, my lord, for minor and minerals, my lord. In the year 20,
Who is
2000
appearing for the response, Mr. Dev?
in the year
Mineral Development.
let me, my lord, let me make my case. Thereafter, my lord, sir will say, and your lordship of, I know your lordship observation was upheld by division bench also regarding appeal.
But still you'll make your submission.
No, my lord, this case is a little bit different, my lord.
Yes.
In the year 2018, my lord, petitioner was granted lease for a period of 5 years. Since the date of getting lease, my lord, petitioner was not allowed to extraction by way of the illegal activities of the local holds. If your lordship will kindly take table to look at page 87 once.
Which order are you challenging, sir?
My lord, let me, my lord, 2 minutes time, my lord.
I'll not hear on merits at all. But what is the order that you're challenging?
My lord, order your lordship earlier occasion kindly, my lord, 2 minutes first. 2 minutes, only 2
You
minutes.
do not submit on merits.
No, no, I am not submitting. I will show your lordship's order.
You have started from the execution of the lease deed, which is not necessary.
No, no, I am submitting just your lordship's own order and the order passed by the ADM.
Yes,
That's
yes,
on, that's much.
yes.
But to the one documents I would like to show. Page 87, kindly see, my lord.
Yes.
This is admission by the, this kindly see, my lord, block land and uniform officer to the IC. This is admission from, now, my lord, there are other documents as your lordship would not like to see. I would not, now kindly take table to look at your lordship's own order. What are the page? Page 109, my lord.
Yes.
Kindly see, my lord, page 110. Second paragraph, my lord.
Yes. Yes.
Now, my lord, kindly take table to last paragraph, third line. Last line. In the light of the observation made in the writ petition, but it is admitted, my lord, petitioner was not allowed to extension by the local holds. And your lordship observed that no steps were taken, my lord. Now, my lord, your lordship directed to consider in the light of above observation, my lord. Now, my lord, my contention is that the next, my lord, the ADM's order, which I am placing before your lordship, starts from page 122. My lord, this order has not been taken into consideration. What I am praying before your lordship, my lord, kindly direct them to reconsider in the term of above observation. Nothing else, my lord.
You were given an opportunity of hearing by the.
Even opportunity of hearing, but this, what's your lordship's order in the light of above observation, that was not considered, my lord. Kindly see, my lord, page, it starts from 122, 123, my lord. First page regarding second page, my lord, kindly see. Force measure.
The illegal extraction part has been taken into consideration, page 126.
My lord, kindly see how this is
Last
taken.
portion of, however, it has been taken into consideration.
My lord, kindly see, my lord, from page 95 to 99, my lord, it was reported to the newspaper the illegal extraction.
Well,
What your
yeah,
lordship says that I have not been
I have just submitted that this part was not taken into consideration.
consideration, my lord.
Page 125, last part, and 126, the authority has taken into consideration
Well,
this.
kindly see, my lord, claim that the business or due to the obstruction from the district authority had all along rendered every possible support to the applicant. Moreover, the fact is also admitted by the applicant further under clause 22 of the list. 22 is separate thing, my lord. If there is a
Continue, please. Have you read the order?
oh, my lord. Yes, I have read subject to your lordship kind correction, my lord. Page 22 is different thing, my lord. Regarding demarcation.
Moreover, complaints were also lodged by the BLLRO against
Had
miscreants.
taken on rates several times to curb the illegal extent. Moreover, complaints were also lodged by the BLR. Is it taken steps, my lord? My lord, observation is that kindly see your lordship observation. I have not been allowed to give the environment.
The matter has been taken into consideration by the authority. You are not happy with the order. So you ha-
I
it
am
is
not only the, I am submitting before your lordship, subject to lordship kind corrections. My humble submission before your lordship is the order passed not in consistency of your lordship's observation.
It is passed in consideration. I'll pass an order.
Well,
And
He is
dismiss
at
it.
liberty to raise all the dispute before the appellate.
My lord, one thing, my lord, in that event, my lord, as your lordship already hold, my lord, and my lord, kindly, my lord, give him some short stay, my lord, not to take third party rights. It was there already. In the order sheet, if your lordship will see. Pending disposal of the representation, no cost, page 110.
What is representation?
It is, my lord, admitted that by the state. Have not been allowed. It is not a case only COVID, my lord.
Is there any threat of coercive step?
Yes, my lord.
Where is the letter? Please show me.
My lord, they undertake that not to take any thought. I will not say anything, my lord.
Have they taken?
My lord,
any
yes, my
step?
lord. Already, my lord, my learned friend knows better than me. Already the process is going on for declaration of tender.
It is a fact.
It is not with regard to this particular block.
That's
Now,
undertaking.
Lordship, may I just indicate one thing. Subject to submission of the feasibility report by the district administration that these lands are incumbents free. Only those blocks have been put into auction by the mineral development. No other blocks, unless it is reported to be encumbered free, WMDDCL will put in the same block in auction.
So, my lord, kindly, my lord,
This
record
has
that.
made out that this particular block is going to be
So
auctioned.
can I record your submission?
Yes, my lord, my block, if my land has not been taken, I have no prayer for entering order.
Rule 51.
Rule 51.
I relegate you.
Yeah, our lordship's order has been upheld by the division bench. No need.
26th May.
Yes, that I mean, so. It's not for my case will end.
No, I'm not granting any stay. I'll only record the submission of Mr. Shah that this land has not been put into auction.
And because my lord, that is 26 May order date. And your lordship's order was.
Yes, if in the meantime, my appeal will go.
Lordship, may I just kindly indicate one thing? My submission was that after getting report from the district administration that this particular block has not been, this particular block rather is
Free from all
encumbered
encumbrance.
free. Only those sand blocks were put into auction.
Well, if my land is not, I have no.
That doesn't include the petitioner's land.
Yes.
Yes, as on that, it has not been circulated
right.
that these blocks.
From May to August, nothing has happened.
No, my lord, if my land, my purpose will be solved because I will file an appeal, my lord, before. If during the appeal, if they will, then my case will go.
The order passed by the additional district magistrate and district land and land reforms officer, comma, Purbo Bardhaman on 26th May 2023 is under challenge in the writ petition. Stop. The said order is amendable to appeal under Rule 51 of the West Bengal Minor Minerals Concession Rules 2016. Paragraph in view of the above, comma, the petitioner seeks to withdraw the writ petition and prefer a statutory appeal before the concerned, before the appropriate
Divisional
forum.
commissioner.
Before the appropriate
Appellate.
forum. Paragraph, the writ petition is accordingly dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to prefer a statutory appeal before the appropriate forum. Paragraph, in the event the petitioner prefers the appeal within
10 days.
within 10 days from date, comma, the appellate authority shall deal with the appeal on merits without dismissing the same on the ground of limitation. Paragraph, it is pertinent to mention that learned counsel for the, your respondent number?
So number 2. Just number 2.
Yes, respondent number 2, my lord.
Second respondent submits that the upon receipt of a report to the effect that the plots are free from all encumbrances, comma, the said plots are put on auction. stop. As on date, the plot in respect of which lease was granted in favor of the petitioner has not been put on auction.
Kindly frame a time limit for appeal, my lord, division commissioner.
No. There shall have been no order as cost. I do not know how many matters are pending before the appellate authority. I cannot direct the appellate authority like that.
The time frame, my lord. As
I have
expedient.
asked them to consider on merits. Don't you think that is sufficient?
Yes,
Otherwise, you have the limitation issue also before the
yes, yes,
authority.
that I get.
Shouldn't the meaning of it?
Number 8.
May it be so.
There shall have been no
Lord,
order as
item number
cost.
8.
Separate website copy. You don't have it. Nothing started. Yes, 8.
My lord, I am waiting for the respondent number 4.
Yes, petitioner. You are appearing.
The petition led by Mr. Mukherjee, madam.
Mr. Shobhan Sengupta and Mr. Shonatan Paja they are not there in the panel.
My lord, it seems state is not appearing.
Yes,
State is not appearing. The last location you lost.
are they in the panel? Because there has been a change of panel.
On the last occasion, your lordship has recorded an order desiring Mr. Chondicharan De to represent the petition. That's my information.
10th May, order of 10th May 2023.
Yes, Mr. De, you are appearing in this matter. I don't know why Mr. Shengupta's name is recorded.
Report.
May I proceed, my lord?
Yes, Mr. De, are you ready?
Report apni file করেছি।
Yes. Because you have. Mr. De doesn't have his brief today, sir.
এইটা রিপোর্টটা আপনি ফাইল করেছেন।
A report has been filed in obedience to the order of Justice Mantha.
Yes, yes.
May I proceed, my lord?
Yes, shall we start? Yes, there is a report.
Should I proceed today?
The fourth respondent, you have not filed any report.
My lord.
You have filed a
Fine.
report?
There also.
Yes, please proceed, Mr.
My lord, kindly turn to a list update which will be handed over to your lordship by Mr. Ali, who is appearing with me. And also kindly pick up
List of dates.
the report filed by the state. Report filed with the state.
Yes.
My lord, in the report, my lord, your lordship at the top. Your lordship will find, my lord,
Yes.
under serial number B, is a matter under Act 248. Under serial number B, it is reported the property was requisitioned on 15th of January.
Serial number B of the report.
Your lordship.
Serial number B.
B, serial number B.
At page?
Page
Page
3, my lord, page 3.
Page 3. Yes. Serial
The
number
above-
B. Yes.
The above land was requisitioned by the additional district magistrate Malda as the person authorized to make the order under section 3(1) of Act 2 of 1958 on 15 January 1987.
Yes.
Next date, my lord, is in D. Notice under section 4(1)A of the said act bearing success number was issued on 9/2/1990.
Yes.
My lord, then my lord, E, award of the above acquired land was declared with the land acquisition collector on 19th September 1995.
Yes.
Look at my list of date. I have taken the dates from him, proceeding on the basis of the report submitted by the. Kindly pick up the lot by short list of dates.
Yes,
87 is the date of requisition from their report.
yes,
Into 1990 is the date of the section 41A notice, publication of the note. Now, West Bengal Land Requisition Act was amended in 1994 with effect from 31/3/94. Kindly turn to the list page. In terms of the proviso to section 7A, the West Bengal Land Requisition and Acquisition Act 48, the period for making expired. That your lordship would have a look at section 7A, the full bench judgment of Justice Pascal Bhattacharya. The last date, 7A, kindly have a look at 7A.
you have the 48 hours.
Is it?
Melody 7A was introduced in 1996 with retrospective effect from 1994. Look
Yes,
at the footnote below. Introduced in 1996 with retrospective effect from 1994. Your lordship need not worry about it. It's all covered with the full bench. Now, my lord, then in 1994, section 7A says, kindly look at it. The collector shall make an award under subsection 2 of section 7 within a period of 3 years from the date of publication of the notice in the official gazette under section 1A of section 4. And if such award is not made within a period as aforesaid, the notice shall lapse. Which will lapse? Section 4(1)A notice shall lapse. Now look at the proviso. We come under the proviso because 4(1)A was published before 7A was introduced. Provided that in a case where the said notice has been published more than 2 years before the commencement of the West Bengal Amendment Act 1994, the award shall be made in a period of 1 year, the date of commencement of that. Therefore, if published before the amendment,
yes,
the award is to be made within 1 year. Kindly look at my list of full bench judgment. Kindly come to my list of dates. I have given the date.
yes,
Everything has been is covered with the full bench. Kindly look at below 9/2/1990 is the date of publication of 4(1)A in my list of dates. That is taken from the report. Then amendment brought into force. Amendment of section 7A was brought into force on 31st March 1994. Because it is 4(1)A was published before the amendment, under proviso to section 7A, the award is required to be made within 1 year from the date of commencement. Now, in
Yes.
this, down to the list date, 1 year is expiring on 31st March 1995. And the award was made according to them in the report on 19 September 1995. Beyond. That is it's an invalid award. The proceeding had lapsed. How do I say so? Kindly turn to full bench judgment reported in 2011. Mr. Ali, do you have a copy of it?
No.
2011, volume 3, CHN, Calcutta 555. Below, kindly turn to paragraph 19 and 20. Paragraph 19. May I explain paragraph 19? Miller,
Yes.
after the expiry of the Act 2 of 1948, Land Acquisition Act of 1894 was amended. Section 93A and 3B was Land Acquisition Act of 1894 was amended to save some of the acquisitions. Paragraph 19 deals with amendment to the Land Acquisition Act of 1894. The Land Acquisition Act of West Bengal Amendment, which came into operation on the midnight between March 31, 1997 and April 1997, prevented all those notices under subsection 1A of section 4 issued after April 1, 1994 from being lapsed by giving scope of revival by a notice under subsection 3B of section 9 of the said Act, 1894 Act. If award had not been passed within 3 years from the date of publication of such notice, and we should otherwise lapse if the said Act of 1997 not come into operation. 20. However, in respect of those notices, section paragraph 20, this is our paragraph. However, in respect of those notices under subsection 1A of section 4, which were issued prior to 31st March 1992, our notice under 4.1A was issued in 1990. Kindly look at the list of date, 1990. And in respect of which no award had been passed by March 31, 1995. Those notices had already lapsed. What the full bench is saying, if before the Land Acquisition Act amended Act came into force, if the earlier proceeding had already lapsed, you can't revive them by section 9.3. They become dead. They are incapable of being revived by taking recourse. Kindly look at paragraph 20. They become irretrievably lost.
Yes.
In our case, kindly look at our list of date. Our 4.1A notice was issued in 1990.
9 February, yes.
The amendment came into force in 31st March 1994. Therefore, more than 2 years back, it came into force. That is their affidavit. And
yes,
time to pass an award expired on 31/3/1995. That is the last date. And they issued the award or made the award in September 1995. Therefore, the award is invalid. I am entitled to have it squashed by your lordship and pass and pray for consequential relief. The proceeding is void. Article 300A says nobody can be deprived of his property save under the authority of. This is my short prayer before lordship.
Yes, Mr. Dev. On the next date? Very well. Mr. Dev wants to make his submission on the next date.
Very well.
What about you, sir?
My lord, as
Fourth
on date,
respondent, yes?
respondent number 4. My lord, I have been given the land. The land has been
You are the
acquired.
requiring body.
I am the acquiring body. My lord, as on date, the land has been acquired and has been given to someone else for development. It has been given to.
But this strikes at the root.
Derivative interest. If
The
the
award
principal
passed on September 1995.
So it is for Mr. Dev to respond actually.
Because adequate compensation has been paid from our side. We have paid the state, and thereafter the state has given us. We have given it to someone else for development. The land is not with us as on date.
Land is not with you also.
The land has been given to Ganapati Grill Factory. It has been
Yes.
given to them for development.
The land has been handed over to a third party, sir.
Because that party is having a derivative interest. If the acquisition fails,
Yes.
their title also fails, there cannot be an escape. The acquisition fails, all subsequent transferring will be affected. And kindly I have a inquire
let
from
Mr.
them.
Yes.
Kindly inquire from Lanson Lord, I don't know. When it was given, do you have the
Was
date?
it transferred?
My lord, in 2022,
That
Oh,
is
very
this-
recently,
very recently.
2022 only.
this
Initially it was
affected,
given
I
to,
did not make them party.
initially it was given to,
Affected by lispendence during the pendency of this matter, they'll be affected.
Yes, it's during pendency of the writ petition that it has
yes,
happened.
initially it was given to Malda Development Authority. They could not develop it. They have returned the land to us. Thereafter an auction has been made and this land has been given to this
That
Ganapati.
is during pendency of the writ petition.
My lord. My lord, what I can propose if if the writ petitioners is willing to, they can seek compensation for this land. Because the
The proceeding
compensation has
has
been,
lapsed, you have to give back the land. There's no question of compensation. Or if you want to still acquire, you have to come under the 2013 Act. That's the only option left. Let Mr. Dey come back.
my lord.
Third learned counsels for the petitioner and the fourth respondent. Paragraph. On prayer of the state respondents, the matter is adjourned. Paragraph. Let the matter appear under the same heading on 5th September,
Grateful, Worship.
since it is substantially heard.
Grateful.
5th September.
Nine.
Yes, item number 9.
It is Joshua. A similar matter was moved before your lordship. On the earlier occasion also, the same report has been filed. The petition before your lordship was prayed for that consideration of their application for the purpose of holding arbitration. I'm drawing lordship attention so far the report filed by the state, page 4.
Your application for arbitration was not considered.
Yes. Page 4, my lord will find. Initial application.
Yes, page 4.
The brief history and consequences, my lord, it is the state. My lord got it. As per case record, the acquired area of plot number 760 is 0.05 acres and the compensation of the award of the Sheikh Rafatullah Islam and others. The acquired area plot number such and such is 3 acres, Rafatullah Sheikh and others. So, but these two are the in respect of the land in question. As per the structure book, a structure was lying both plot number 760 and 760 by 4921. My lord got it.
Yes.
Of the Rafatullah Sheikh and the compensation of structure was paid to him in plot number 760 by 4921. The copy of the structure book is structure. Rafatullah Sheikh applied for arbitration on 16/8/2017 and his demand was enhancement of value. He was received the money for the value of structure value such and such after the Limitation Act. This has more than 3 years. Therefore, the petition was not entered. The petition was not entertained. The arbitration was so. It is the case made out by the. This is barred by law of limitation. Now, can I turn to my application? Page 22 of my writ application.
Page 22.
Before that, my lord, can turn to page 21.
Yes.
My lord will find this is an application for getting the compensation rest of the structure, because I have categorically mentioned দাগটি অধিগ্রহিত হয়েছে, অধিগ্রহিত জমির উপর আমার বাড়ি বাথরুম আছে, ও দাগের জমির ক্ষতিপূরণ বাবদ টাকা পেলাম, কিন্তু বাড়ি ঘরের কোনো রকম ক্ষতিপূরণ পেলাম না. That is admitted in the report also. In the 2 plots, my lord, your lordship will find the structures were there, out of which in the set of 1 plot, the payment was made. It is admitted fact. Now, my lord, they cannot reconcile from their own at least statement. So far, my lord, then, my lord, your lordship will find the next page, page 22, 16/8/2017.
This is the application.
This is the application. Even if, my lord, according to them, if it is appears, my lord, the land includes structure, whether there is any finality regarding my compensation or not. If that be so, my lord, I am entitled to file arbitration. And my lord, this is statutory arbitration. In absence of any limitation, whether, my lord, they can reject my application, for it is barred by law of limitation. একটা এই যে জাজমেন্ট ছিল, আর একটা জাজমেন্ট ছিল সেই ইয়ের
Yes.
হরিশ ট্যান্ডন সাহেবের,
Yes, Mr.
যেটা in absence of any limitation act
My lord,
regarding arbitration, the statutory arbitration, and this is the same kinds of matter. My learned friend appears also.
আপনার ক্লিয়ারটা কি এখন?
আমার arbitration application শুনানি করো. So I can raise my point of structure in nature of the arbitration also, but I did not.
The limitation part was not submitted in this.
That is the only thing. The limitation part, my lord, if your lordship, my lord, to the limitation under the statutory arbitration, my lord, there is no provision for limitation. And in absence of any limitation of application for the purpose of rejecting my application, statutory arbitration, then, my lord, I have a right to make an application for the purpose of arbitration that must be in the reasonable period. So, my lord, in 2017-19, it's 3 or 4 years. If the act says 3 years, my lord, it cannot be said, my lord, within 4 years it is barred by law of limitation. Because, and another thing, my lord, structures they have admitted so far the 760 not
One
been
of
paid.
the plots they have given and one of the plots they have
But,
not.
this is my prayer that my arbitration application be considered in that aspect.
My lord, his prayer is otherwise, my lord. His prayer is, my lord, to assess and disburse the compensation. My lord, his prayer is otherwise.
কোন প্রেয়ারটা?
পুরোটাই. And lordship, the second prayer is lordship to hold the arbitration under section 3H5, my lord. Lordship, my learned friend, lordship, filed this application in the year January 2019, and lordship, the arbitration proceeding was initiated in the year 2019, November 2019, my lord.
Was
So
he
he's,
heard?
my lord, he is not heard, my lord. As per his, my client, he said, Lord, my learned friend said he is not heard.
It is
But
not
my
in
lord,
the
my
report.
submission, it is not a premature, my lord. I'm asking this question to myself.
Why?
My lord, he filed this application before the initiations of the arbitration proceedings. And he never said so due to accept my arbitration application, lordship. His prayer is otherwise. To accept, lordship, rightly or wrongly, lordship, as per section 3G1, the competent authority adjudicating the compensation and disburse the compensation. And lordship, he cannot, lordship, at this moment, lordship, he is a functus officio, he cannot revisit his own calculation. And after that, lordship, as per the section 3G5, lordship, the NHI Act given the power to the learned arbitrator to modify the award passed by the competent authority. Lordship, as per this, lordship, has already been enhanced these compensations, lordship. Whether my learned friend is aggrieved, lordship, he can, lordship, file this application before section 34.
Which compensation has been enhanced?
Lordship,
According
in terms
to
of the MOSA, lordship.
In accordance, the state's report says 2 plots. Land has been granted in both the plots, but with respect to structures, one of the plots it has been granted. The other plot, structure valuation has not been granted.
Lordship.
That's the report of the state. The petitioner filed an application which was not considered, 3G5 application.
My lord, that is, lordship, prior to that, lordship, because this application has been, lordship, this initiation in the month of November 2019.
Does the arbitration proceeding have any connection with the petitioner's case? Petitioner's
Lordship, that is not lordship, but where is his prayer, lordship? His lordship, how lord, my submission is lordship, in the month of January 2019, his prayer is lordship to disburse the compensation. And lordship now, lordship, after the, in the year 2023, lordship, he said to accept my arbitration proceedings.
Probably my learned friend not going through the entire prayer, my lord.
Yes, this.
What my learned friend is praying, prayer, read in the nature and coordinate response to assess and disburse the compensation amount to petition interest of the land and structure of the petition standing over plot and lying situation and district Murshidabad, the LR diagram 760.
Yes.
That is the plot which is irrespective of which the structure has not been paid.
760 structure has not been
Paid.
assessed. Admittedly.
Lordship, subject to lordship's correction, lordship, his prayer is lordship now, lordship, to accept my application.
Not accept my application. Community also is to hold arbitration.
As far as my submission, lordship, in the year 2019, we have already deposited this amount. Lordship, I have already done my part, lordship. But the point is, lordship,
have
at
done
this
your
moment,
part
this petition is maintainable, lordship.
You
This
have
is
done
my
your part under 3G1, not 3G5.
lordship. My submission is, lordship, as per my report is concerned, lordship, only the 3G5 has already been completed.
But the petition is not governed by that 3G5.
I'm not part
Because
of that.
petitioner's application was not taken into consideration at all. And the petitioner was not given a.
Where is his prayer, lordship? That is my case, lordship. Where is his prayer, lordship? In respect of this, to lordship, to hold as per section 3H5.
To hold, yes.
B, prayer
As per
B.
section 3H5.
Prayer B.
3H5, my lord.
3H5 should be 3G5.
No, my lord. No. How, my lord? At this moment, lord,
Arbitration,
3H5 is totally different
arbitration
thing.
is under 3G5. 3H5 it is technical defense,
Kindly
my lord,
this-
prayer,
this
my lord.
type of things, lordship, and lordship, kindly amend these petitions, lordship. I have not on his way, my lord. But this petition is have to be rectified, my lord.
P4 is, my lord, can you consider this is, if my lord, my learned friend is on the point of rectification, P4, what is P4, my lord? This is an application for holding arbitration. P4, what the notice?
On the basis of this one, page 22, the notice has been
Issued or not?
I specific instruction is that they were submitted to the.
Yes.
His specific case is that you have not accepted the application since it was barred by limitation.
My lord, can you consider the report? Then how this authority is acting, my lord, in the statute, my lord. Therefore, Rahmatullah says applied for arbitration 16/8/2017. 1, 2, 3, 4, 5th paragraph of their report. Report.
5th paragraph of the earlier report.
Earlier report. Rahmatullah Sheikh, my lord, your lordship find. And that is a document which I have annexed. And it was not taken into consideration because it was fine. So, my lord, this report has been prepared as per the choice.
Please come to the earlier report.
That has not been made accepted.
So he went to file, you have not taken it. And in the next report, you say that he has not filed.
There is a limitation, but it's admitted that there is a limitation.
Please show
Yes,
me the-
yes.
Please show me the law, the provision.
Statutory arbitration in absence of any provision as laid down in the
In
statute.
any matter, it is reasonable time. But
This-
there is nothing as limitation.
I have submitted your lordship. This is within the period of limitation.
Yeah, arbitrary concept, they are clear and therefore allowed for enhancement of land value and structural.
Arbitrator has considered their prayer. When you have not accepted the arbitration application at all, how did you consider? How many arbitrations can be held? Yes, that is 3G1.
As per record, the required area of plot number. Required area of plot number such that and from that.
G5 before the arbitrator.
And what they're doing, my lord, in the previous cases, my lord, your lordship was direct to hold arbitration. They have gave the answer already. Arbitration is held, so there is no occasion on the part of the authority to hold subsequent arbitration. This is the. I'll come with those documents. What a person.
Authority doesn't follow English, not the law. This is very difficult.
Well,
They follow both, isn't it?
And they are one of the IAS officers, the divisional manager. Well, can you consider this?
Fortunate state of affairs.
So even if under the law, if my learned friend, because these are the implementing authority, without making any payment, whether they are entitled to make any construction over my plot of land, they've admitted they have not paid. CH1 has not been paid. It is not that the arbitrary amount. CH1 have not been paid. If without payment of CH1, my lord, the authority can take away my land or structure. They have demolished, they are making the construction. They admitted, yes, I have not paid. Well, can you consider the
File your application, I'll give a time bound directive.
yes, and then some of the rest of structure, rest of the 760, that may be the prayer A. Already arbitration here, so your application in terms of the order that was communicated to us. না 760 দেবে তারপরে তো arbitration করতে পারবো স্ট্রাকচারে অ্যাসেসমেন্ট ওই তো
You have not implemented the arbitrator as
no
a party?
Malar, at that point of time Malar, the district magistrate was arbitrated.
Not
That's
the
a
divisional
division
commissioner?
Malda commission.
On prayer of the petitioners, comma, liberty is granted to implement the divisional commissioner, comma, Malda, as respondent number 7 in the writ petition. Stop the cost title of the writ petition be amended accordingly.
And also the prayer Malar giving liberty. Prayer is not the affidavit portion. That power, that liberty I can ask for.
3H will be 3G.
3G. Typing system. Because in the
Well, 3H5 is totally a different thing.
Yes.
yes,
Section 8.
that I am admitting.
That Mr. Roy is aware. That's why he's
That
further liberty is granted to the petitioner on his prayer to amend prayer B, capital B of the writ petition. Paragraph, heard learned counsels for the parties. The petitioner, yes, claims to be the recorded owner of the plotting of the plots in LR DAG numbers 760/4921 and your writ petition is full of mistakes. Please come to paragraph 2. Withdraw. I will not pass an order like this. 707 is your plot. Paragraph 2 of your writ petition.
That number 760 by 491 and 707.
707 is the DAG number. I will not pass an order like this. Entire writ petition has to be amended. What is this? The first prayer is also wrong, if I may point out.
My lord.
You have asked for structure, land, everything in the first prayer, prayer A. It should be only for the structure in 760.
Only for the structure.
So how many mistakes will you correct? If you want to call Mr. Roy, you can. Withdraw, I'll give you liberty.
Kindly, my lord.
Yes?
Kindly, my lord. Keep sick, my lord, after 5 minutes. I'll come.
5 minutes.
Since Mr. Roy has just made his submission.
My lord, can I take it tomorrow, my lord? My lord, that is the entire lord, that is their prejudice, lordship. My lord, in that case, my lord, if that point, lordship, I have to take in this, it is their lordship, their,
Allow them to withdraw because several corrections have to be made. Yes, will you please call, send for Mr. Roy? Withdraw. Yes, call the next matter, please.
Item number 10.
Switch on the microphone, please.
On the last occasion, Lordship, your Lordship directed to the state to file a report, but state is not here.
My lord, also last time we have submitted one report, my lord.
Yes.
Report, my lord, page 10.
You wanted to come back with further instructions.
We have received my further instruction, I kindly see page 10. My lord. Page 10 of my report. Here, my lord, the date of joint inspection was mentioned as known as 15th of June 2018. And at the bottom, my lord, it's my lord, 20th December 2017, it has been written.
Yes.
You lordship asked me to take instruction how, my lord, 2017 downloaded of 2018 report.
Yes.
But my instruction is this is the file number.
Which is the file number?
Computer where my lord will generate some my lord, documents after giving some file number. This is the file number. 20 December 2017 is the file number, not my lord downloaded. The download tape. Joint inspection has been held as per law, my lord.
And the field report was also not annexed.
Field report, my lord.
Have you seen the order passed on 25th July?
Yes, my lord. You lordship, only, my lord, after
So you wanted to come back
inspection
with the field report to show that the petitioner was present when the inspection was
page
held.
10, his signature is there, my lord, page 10.
This has been subsequently prepared. The field report which is prepared on the field itself, which bears the petitioner's signature, attendance.
But the page, my lord, 11 is the notice. To the
Yes.
petitioner. And on the basis of this notice, inquiry has been done. And this is the report, my lord, page 10. And here, my lord, the signature of the petitioner is appearing. From Das, landowner.
Page 10 is a report which is prepared subsequently.
Report of
Please
the
show me the attendance sheet that the petitioner was present at the time of joint inspection. That was the direction in the earlier order. It cannot be ascertained whether the inspection was held in presence of the petitioner or the signature of the petitioner was taken in the inspection report subsequently. This report is a subsequent report. This is not prepared on the spot. This is prepared after you come back to the office.
Yes.
I want to see the spot report where the petitioner has signed that he has attended the inspection. The inquiry. That was the direction on the earlier date.
The downloaded copy, you will the order.
There were two issues. One is the downloaded copy. The other is the attendance sheet. A learned counsel for the state respondents seeks to submit a further report in compliance with the order passed on 25th July 2023. Paragraph, let the matter appear under the same heading on 18th September. Yes.
My lord, kindly grants me liberty, my lord.
I'll grant you liberty, yes. Raji, wait a minute. Agata. Learned counsel for the petitioner seeks to withdraw the writ petition on the ground of certain defects detected therein and seeks further liberty to file a fresh writ petition on the same cause of action. Paragraph, in view of the above, the writ petition being WP such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to file a fresh writ petition on the same cause of action. Paragraph, there shall however be no arrest to costs as in certified website.
This is the punishment. These are the jury.
Several mistakes.
I used to only, my lord, after some responses should, it's my fault, my lord.
You're not supposed to check every page.
My lord, it is my fault, I should have.
Next.
হ্যাঁ ঠিক আছে এটাই তো
This is for non-prosecution.
And what you call a punishment is an opportunity. It's not a punishment, it's an opportunity. Next.
Item number. Cut copy paste has done the most
That is the difficulty. Misuse of
Cut copy
technology.
paste.
Misuse of technology.
Initially, we used to write down and make the drafting. That is much more convenient for us also.
Not there at all.
At the time of drafting, we used to memorize the thing
Yes,
what I have seen or I have written. So after going through once, I can recollect what is there. But now, my lord, I'll find this petition is first three paragraphs from that petition.
It
And
has become easier. And I call it misuse of technology.
yes, that's why, my lord. I cannot say anything, my lord. It's my fault, my lord. I should have been.
It's beyond correction. Like there are several.
No. I never asked for anything which is embarrassing for the bar and the bench also. Okay, I know.
Yes.
This is a unique case, my lord, where, my lord, the land which was declared to be a property of the government has subsequently become a Rayati land. My lord, what happened, my lord? This is a road. Admittedly, the road is there. And the flank of the road is under the Highways Act. My lord, your lordship will find that that belongs to the highways up to Nanjali. But curiously enough, my lord, a plot of land, which is, my lord, your lordship will find that is the plot number. Plot number 810.
Who
Though
is
initially
for the private respondents?
I am for the private.
Okay.
810, though initially, my lord, in the record of rights, in the RS record of rights, my lord will find it belongs to the RS. That is belongs to the yes, yeah, building. কোথায় ওটা সেটা ইয়েটা দিয়েছিস এভিডেন্স এক্সেপশনটা দিয়েছিস? Yes. And the status of the private respondent, my lord will find page 38. এটা রিটের কপি থেকে দেখাচ্ছি। কই এক্সেপশন তো page 4, your lordship will find.
Page 38.
No, my lord, the page 4 of the
Exception.
No, exception, my lord.
Yes.
Page 4, my lord, your lordship, and page 13, which is belongs to the Works and Building Department. My lord, got it? Superior landlord.
Page 4 is your statement.
Page 13 of the page 13. Page 13.
Page 13, my lord.
13, 1, 3.
There are 3 page numbers are there.
Yes. Page 13, yes.
My lord, got it?
Yes.
And my lord, your lordship will find next page. So this is belongs to the initially, my lord, under Khotian number 1, my lord, at the top, my lord, got it. After that, it was been transferred to in favor of the Works and Buildings Department.
Yes.
And it was under the same. Now, my lord, curiously enough, my lord, I am serving your lordship. Kindly turn to the current record of rights that your lordship will find. Page number 12, page number 12. Page number 12,
page number 6.
বলিস না আমাকে তোর পাগল করে দিবি আমাকে।
Number 6.
Page number 6.
6 camera.
কি বলিস না? Now, my lord, it is recorded in the private respondent name as Rayat. Property admittedly belongs to the government. Now, my lord, in view of the same, my lord, your lordship will find what the BLR have stated. Your lordship will find that is at page.
The property is recorded in the name of the private respondent.
Yes, Rayat. Rayat has been declared. Page.
Paying rent.
I'm not. Page 12.
Let him complete. You'll have your opportunity.
Page 12
Of
the exception. My lord, একটু জজ সাহেব আমারও ইয়ে হয়ে যাচ্ছে এদিকে।
yes, page 12 of the exception.
Reported. Page 12. In reply to a letter, it was written to the Mukundaram Khatwa. This is by lords. When I came to know about these illegalities, we have informed the BLR how it can be happen and what is the reason for recording the name as a Rayat in respect of the land belongs to, because it is in front of my land. So my access to the public road has been blocked. In reply to a letter such and such, as per the available record, no information is available in the RS Khotian number such and such. Regarding KB Khotian being number at such and such, found that Khotian in favor of Works and Building Department, which I have shown to your lordship. And the possessors, Siddhar Manna, Dakolikar, in remarks column, transferred the same to Pran Krishna Manna by deed number 499, dated such and such. My lord, pause there for a moment. A Jordong is transferring a government land by recording his Rayat status and not noting the remarks, Bhushami Aina 14.3, tier fraud, dated classification Jol. My lord, it is nothing, my lord, it is unheard of. Be as it may, my lord. When this matter came up for consideration, your lordship was pleased to direct to consider the representation that your lordship will find at page in my writ application. Page 17 of the restitution report. Is an application for restitution by consent of the parties, the petition taken up for the petition impugned the order passed by District Magistrate 10(3) of the West Bengal Highways Act. For the petitioner submits that his client is a Rayat. The same, because this is another person, it is by the another one. He refers to a record of rights to establish the claim of the petition. He submits that the land in question is not land, belongs to the Public Works Department. The District Magistrate ought to have taken such fact into consideration. The District Magistrate has rejected the appeal simply on the ground that the order is of removal of encroachment being implemented. It appears from the record that the state authorities has initiated protest under section 10 of the 1964. An order of removal encroachment was passed by the petitioner being agreed by the said order initially filed writ application. It was disposed by an order that such and such for an appeal therefrom. An appeal, such appeal was disposed by being imputed. Petitioner claims right as a Rayat. The petitioner claims right to the record of rights. Record of rights is not a document of title. It is for the petitioner to establish his right appropriate proceedings. The court is informed that the petitioner has already filed the suit and such suit is still pending. So, my lord, the similar circumstances person came before this honorable court and it was held that you are claiming to the record of rights which cannot be termed as a document of title. My lord knows better than only the at best the position. Now, my lord, on this score, my lord can turn to the order which was passed by the yes, order. What they reported there? The report there. Now, my lord, can you takes up the report filed by the state?
Yes.
Page 4 onwards, I am drawing losses one by one.
4 is the same document.
This is the KB stage, well, because the final assessment is not found anywhere. This is a KB stage. So, at best, my lord, if your lordship may consider the record of rights, my lord, unless the finally published record of rights, my lord, the evidentiary value, my lord, will know better than us, my lord, what is the evidentiary value. Now, my lord, can you turn to the next page? That is CS. Bharat Sarkar Pokhe collector. My lord will find that is
yes,
belongs to the government. And page 8, my lord, your lordship will find
yes,
and is Dakolkar. Now kindly turn to the LR record of rights.
Page 8 says Rayat.
Yes. Rayat, my lord, on the ground of Dakolkar Rayat. Dakolkar versus Puja. If my lord can be turned in that way. ইংরেজি এত তারিখ এর কে মূলে মানে কক মূলে পান্নালাল মান্না পিতা প্রাণকৃষ্ণ মান্না সাংনিজ অংশ এগারো রায়ত. But what is the effect of? I have no idea regarding this because the RSC it stays in the name of the person, the government. Then, my lord, the under that at that point of 1956 Act does not come. There is no question of vesting at that point of time. Be as it may, my lord, can you turn to page 16?
Yes, 16.
Now, my lord, this is a LR record of rights converted in the name of the same. Now, my lord, kindly consider if that is why the previously, my lord, this honorable court directed that only on the basis of the record of rights. I prepared a supplementary affidavit on this aspect, my lord. I could not serve it. I mean, there, my lord, the bearer himself is now saying, yes, there is some wrong has been committed by us. That is the page I have annexed, my lord, we somehow get regarding correction of the R in plot number 810, my lord, got it. In persons the above referred memo. Now the assistant engineer, after receiving the copy of this writ application, my lord, somehow has been his undersigned has been requested to correct the LR record of process. The office of the undersigned has already taken up the matter and scrutinized all the records and documents relating with the issue. Present the matter has been forwarded to the Honorable ADM, DLR, Purvandipur by order such and such for further action. So, my lord, the entire thing has been done with us. Clarifies the every right. The person who is the owner of the land is not coming forward, and the person who is in occupation, how they can Jordog can be termed as a riot, my lord, in before the Registration Act. What, my lord, I am praying before lordship as on this day. My lord, as till their name is appearing in the record of rights as a riot, my lord, prima facie he is in occupation of the land. He can be termed as a riot unless there is rebuttal presumption on my part. So therefore, my lord, if your lordship may kindly consider this.
A suit is pending.
No, in respect of this person, there is no suit. In the other one, same the plot belongs to some other person. In the earlier occasion, the proceedings initiated by against another person. The same proceedings has been only for the purpose of my lord's judicial review. That this was considered, and in this honorable court held that only the record of rights is there, so it cannot be termed as a. You can file a suit.
I think there is an observation that a suit is pending.
Yes, between the other in that case,
matter. They are relying that order before your lordship. That
it is separate. It not belongs to this petitioner, my lord. The same adjacent plot of land, the same facts and circumstances.
The same plot.
Yes, no, adjacent plot, but the facts is the same. 810, that public works department was there. Subsequently, their name was recorded as a record as a riot. So at present, my lord,
What is your prayer?
now, my lord, my prayer was that to initiate proceedings is the government land. Now, on the basis of which now subsequently it surfaced that it belongs to the, it recorded in the name of private individual. Now, if my learned friend can apprise your lordship was actually belongs to the government or PWD.
Unless that issue is settled, your writ petition cannot be considered.
That's why, my lord, that's why I started all these things. Now the government is only the authority can come forward and say, my lord, whether it is a plot belongs to the government or the private.
Yes.
Petitioner, my lord, before this court approach with a very limited prayer that private respondent has encroached the government land, the land in question, plot number 810, take appropriate proceedings and free the government land. That is the limited prayer. My lord, after this petition, we have thoroughly made inquiry, and my lord, we have filed our report in the form of affidavit. My lord, kindly come. Page number 2 of our report, my lord.
Page number 2.
2. I want to rely upon the average, my lord.
Yes.
After, my lord, finally, it has come after inquiry, the land is not PWD land. Now, my lord, I am specifying. At, my lord, Roman 1, the subject land, my lord, stated 810. Next, my lord, that from the KB Khotian records, it appears that the said land was recorded in favor of the Sridhar Chandra Manna, son of Dinobandhu, and his status was Dokolidar. He was upper tenant or intermediary under, my lord, works and building department. Thereafter, my lord, we in this paragraph, my lord, we have annexed the, my lord, annexure, which already shows, my lord. Kindly see, my lord, page 4. The Sridhar Chandra Manna is written in the just left side, my lord, and on the right side, his status was Dokolidar. And my lord, upper just upper portion, 1 taka 69 paisa, that is, my lord, on the left side written works and building department. So, my lord, Sridhar Chandra Manna was the upper tenant under the works and building departments. Thereafter, my lord, kindly come back, my lord, averments that it was also transpired that in the RS stage, the operation of the Dokolidar used to pay land revenue to the upper tenant to the tune of 1.69 paisa, what I stated just. The payment of land revenue to the explicitly indicate the rioti settlement. Next, my lord, that from the KB record, it appears during the preparation of modified Khotian of the land was transferred to Pran Krishna Manna. That is, my lord, the deceased father of the private respondent, son of Troilukya by Sajan sir. Thereafter, after his death, my lord, the private respondent names have come in the my lord LR. Now, my lord, petitioner, what I stated earlier, petitioner came with a very limited prayer, and my lord, whether the land belongs to private respondent or in other name, that is to be decided by the civil court. And my lord, this is not the civil court of fact finding authority, my lord. Kindly consider this aspect. Our report, the land is not ours. What more? And my lord, one thing I want to clarify, because I have talked with the my lord concerned PWD officer. My lord, kindly, if my lord come page 15 of their exception, they are showing, my lord, a notice of the assistant engineer.
Page 15.
15 of their exception.
Yes.
They are relying upon a notice of the executive assistant engineer. That assistant engineer sent a communication to the PLRO that such and such
Correction
land,
of record offense.
for correction of record. If it is a government land, then kindly correct the record. I have, my lord, stated personal talk with the person personally with the assistant engineer. He said, my lord, that is, my lord, written on the miscommunication. If I say that the one RTI has been preferred before him, and on that basis he requested the BLRO, if the land belongs to the government, then correct the record of right. But my lord, ultimately the land in question 810 is not the PWD land, but it was a Raiti land. And whether it is Raiti or not, otherwise, but that is to be decided by the appropriate civil court.
So if the government is coming for to say it is not my land, there is no occasion on my part to I have to file a suit. এটা কি আছে মেমো নাম্বার বলে দিচ্ছে গভর্নমেন্টের ল্যান্ড আর এটা কি আছে
It is completely civil dispute. Kindly see paragraph 5 of the repetition.
I have not
Kindly see. I am
The government is speaking for you, sir.
my lord. I am holding registered document. I am in possession. I am paying rent
I have not disputed
since 1970. That document has not yet been challenged. I am in possession. I am paying rent. Kindly see paragraph 5 of the repetition, my lord. It is completely the civil dispute, my lord.
All the private respondents are in possession.
My lord, my lord. 7, 8, 9, and 10, and rest are my tenants. Kindly see paragraph 5 of the repetition, my lord. May I read it, my lord? That your petitioner states that after the purchase of the said 2 plots of land, petitioner purchased adjacent 2 plots of land, and after erection of structure over the said plots, your petitioner enjoys the same in khas possession. But the private respondents create all sorts of disturbances in the enjoyment of said riot's land. Those 2 plots of lands of the petitioner, allegation is that private respondent is creating disturbance. Said riot homestead, riot land and structure by forceful obstructing the portion of the petitioner said riot homestead land. Portion of the petitioner's riot homestead land, not the PWD land. Their allegation is regarding the private dispute, encroachment of private land. Without recording evidence, my lord, this dispute cannot be adjudicated. This court is not, my lord, proper forum, my lord. Kindly send the parties to the civil court.
Next paragraph.
Kindly see this.
Next paragraph. Paragraph 6.
Next paragraph, please. Next line. This case has been made out. Actual, my lord, civil dispute. Allegation of encroachment private land. Without recording evidence, this dispute cannot be adjudicated, my lord. Kindly relegated to the suit, my lord. Private respondent holding registered documents, my lord, registered deed, transfer deed 1970. Kindly relegated the parties to this, my lord.
I'll record that this is a.
My lord.
Record of submission.
This is civil.
Supplementary evidence
এখানে স্টেট নিচে বলে দিচ্ছে
submitted on behalf of the
এখানে স্টেট কোথায় বলেছে প্রাইভেট
petitioner is taken on record.
it is not my property
Paragraph.
এখানে যদি হয় তাহলে এটা রেকর্ড অফ স্ক্র্যাচ হবে
The petitioner contends
কোথায়
that
স্টেটের সাবমিশনটা কোথায় স্টেট অ্যাডমিট করছে it is not my property সেটাই তাহলে সেটা যদি আপনার এখানে তো স্টেটের স্ট্যান্ডার্ড ছিল না
the private respondents have raised unauthorized structures
এবার বাবুঘাটে যাবো আমি
on the government land
যেটা দেখাচ্ছি
adjoining their property, comma, thereby blocking their egress and egress.
My lord, private respondent number 8, 9, 10 and 9, 10, 11 and 12. Rest are my lord, tenant under me, under private respondent.
So the blockage is according to the petitioners, all the private respondent. That's the plain case.
Yes, that is the case that the though it is not been happily expressed, my lord, this is the fact that this is
All the private respondents.
all the private respondents are making blockage to access by to the state highways. That is the only.
Learned counsel for the petitioner takes this court to the
আর কিছু করার নেই। My lord, I have to
RS record of rights.
Babughat. I have to go Babughat. 652. Babughat.
Run, yes. RS record of rights, which demonstrates that the plot was initially in the name of the collector and thereafter in the name of Works and Buildings Department. Stop.
Initially in the name of the Union of India, my lord.
At the British era.
Pashchimbanga Pokkhe collector.
No, my lord.
Subsequently collected.
Just a minute. First of all, the Union of India, my lord. Annexure P3 of the writ
I'm
petition.
referring to page 13 of the exception.
My lord, the Bharatashra, that keeps Union of India, my lord.
Pashchimbanga Pokkhe collector, not union.
My lord, for a moment, my lord, kindly come to writ petition, my lord. Annexure P3,
Annexure P3 page.
page 37, my lord.
Page 37 only.
Bharatashra, that means the Union of India.
Bharateshwar cannot be Union of India.
My lord, that in the British area.
British era.
British period.
Sri Bharateshwar Union of India.
My lord. And that period, that was in that style, my lord.
I don't think so, my lord.
No. You have don't think.
Because you've pointed out page 13 of your exception, which says, because this is irrelevant now.
Yes,
In the CS record.
কি বলে?
আরে এখানে তো বলছি পশ্চিমবঙ্গ পক্ষে
ও
collector.
হো আমি দেখাচ্ছি না কেন কেন কথা বলছি একটু বলুন না
Subsequently, the name of Sridhar Chando Manna, Chando আছে না? And thereafter,
My lord can get
Pran
assistance
Krishna Manna
from our report.
have been recorded as Dokholkar, inverted comma.
Rayov. Rayov, my lord. Page number 6.
Where is the LR record of rights?
My lord, that is the last page of the report
petition.
submitted by the state. No, my lord, the state.
In our report, my lord, page number 16.
Paragraph. The private respondents claim to be private respondent numbers 9, 10, 11, 12 are the riots.
My lord.
My lord.
The private respondent numbers 9, 10, 11 and 12 paragraph claim to be riots in respect of the plot in question and submit that respondent numbers 13 to 17 are tenants under them.
Tenants under the private respondent number 8, 9, 10.
9, 10, 11, 12 you
9,
said.
10, 11, 12.
Paragraph. Placing reliance on the report in the form of affidavit submitted on behalf of the seventh respondent, learned counsel for the state respondents submits that it appears from the KB Khotian records that the land in question was recorded in favor of Sridhar Chandra Manna as Dokholkar, and the upper tenant or intermediary was Works and Building Department. Works and Building Department. Stop. The Dokholkar used to the Dokholkar used to pay land revenue to the upper tenant, which indicates Rayati settlement. The land was transferred to Pran Krishna Manna by virtue of a registered deed of sale executed on 3rd February 1970. Stop. The names of respondent numbers 9, 10, 11, and 12 appear in the finally published LR record of rights. The state, therefore, in substance, the state respondents submit that the land in question belongs to respondent numbers 9 to 12. Paragraph. The contention of the respondents is denied and disputed by the petitioner, who challenges the title of the private respondents in respect of the plot in question. Paragraph. In view of the above, this court is inclined to hold that the dispute between the parties is purely civil in nature, and this court, in exercising extraordinary jurisdiction under Article 226 of the Constitution of India, is not authorized to deal with the question of title in respect of the property. Stop. Accordingly, nothing further remains to be adjudicated in the writ petition, and the same is accordingly disposed of. There shall, however, be no order as to cost, urgent certified website copy.
I'm good. Me to approach before the Supreme Court.
Not necessary.
I am the outsider, ma'am.
Not necessary. I have stated that the civil court has to decide. This court cannot decide. Yes.
I am the outsider. I am not the owner of the property. That is the government, and this is my constitution. That will maybe done.
No,
After line add করুন।
In
On prayer of
accordance
the
with-
petitioner,
that may be,
on prayer of the petitioner, ওটার আগে দেবেন, ওগুলোর আগে। যেখানে
my lord, it
nothing
is
further-
completely civil dispute between the petitioner and the private respondent.
No, not at all.
Kindly see the paragraph 5 of the writ petition.
Property belong to the government.
In accordance with law, they may file
Property
suit.
doesn't belong to the government as stated by
No,
the
they are getting,
government.
Development shows.
my lord, if your lordship get the liberty, they will get privilege.
No, nothing, no question of any privilege, my lord.
No liberty is required, my lord. In accordance with law, they can take any step before appropriate forum.
Liberty is very much required.
No, my lord.
All along the property is recorded in the name of the government.
He has no right at all.
Need to take necessary steps, that's all.
My lord, my lord, my lord.
On prayer of the petitioner, liberty is granted to approach the appropriate forum for redressal of his grievance.
I'm getting close.
Shantanu? Yes, next.
Item number 12.
So Dev,
This is my fault, my lord. As per my lord, that I- my lord, this is my lord. Here, my lord, I-
একটা করে করো এফআইআর অর্ডার উইথ করে নি হ্যাঁ ডিসপোজ
please file your report on the next day. Direct counsel for the state respondents seeks further extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 20th September. Please serve an advance copy. Mr. Dev says. Yes, next.
Item number 13.
Same order, same order. 13 and 14, same order, Vasu.
Yes. 13. Item number 15.
Who is appearing for the respondents? 16.
15. The 16, I am for the statement.
16 for the
16. Correct.
Of the state they are, in fact, saying that
Learned counsel for the petitioner seeks to use an exception to the report submitted on behalf of respondent numbers 7 and 8. Paragraph, same day, 20th. Paragraph, let the matters appear under the same heading on 20th September.
There are mentioned before. Actually, the 7 and 8 is relying the report of the state.
State, yes. As well as the state, 7 and 8, as well as the state. You'll file a comprehensive exception to them.
Same matter. Same matter. Same matter. Same matter.
Number 17.
Please switch on the microphone.
My lord, I am for the petitioner, my lord. I have informed the respondent ACL, my lord. This is the my lord affidavit of service, my lord. The matter has been actually been filed in group 9, my lord. They have corrected
But
it.
you
And
served thereafter?
yes, my lord, I have informed him tomorrow, yesterday.
Yeah.
That is the affidavit of service, my lord, but that is old, obviously. I have informed him verbally, my lord, yesterday.
This is also not service?
Yes, my lord.
All of them are not served. Who is appearing?
Yes, my lord.
Yes.
Lordship, I am led by Mr. Shiv Shankar Banerjee.
One of the cases that, my lord, I am praying for disposal of my representation. My
What
lord,
is the matter about?
my lord, the ECL, my lord, has published notification for acquiring lands in Nakarkonda Moja for their AB pit mining project. Now, my lords, they have, my lords, notified for all the adjoining lands, but my lords, not for my land. If they execute that mining project in all the adjoining lands, my land will be damaged. That is why, my lord, I have prayed them to acquire my land as well. My lord, they have informed verbally that they have already acquired it, but my lord, they have not made any written communication to that effect. That is why, my lord, I have prayed for, my lord, disposal of my representation.
Where is your representation?
Lordship, Annex P3, your Lordship.
At page?
Page
Yes.
16. Lordship, we can file a short affidavit, your Lordship.
Why?
Because, your Lordship, this representation, your Lordship, we can consider certainly, but how far this representation is admissible for consideration, that has also been looked into because it has to be looked into, your Lordship. That is the reason, your Lordship. I'm just saying if we can file a short affidavit, your Lordship.
Plus, demand of justice is at page 18, and thereafter other communications is also there at page 21 and 22.
The slip comes in.
These are subsequent communications, isn't it?
Yes, my lord. 18 is the demand of justice, and page number 21 and 22.
Cannot be considered.
Yes, my lord.
Demand of justice cannot be directed to.
Yes, my lord. Page 21 and 22 are the latest.
21 and
21 and 22. Yes.
21, 22, Lordship, 21, 22, the pages are not in my writ petition also, your Lordship, that I find follow here.
What?
the general manager should consider.
Lordship,
The general manager should consider.
General Manager, Bankula area. Lordship, General Manager, yes, your Lordship. Respective area, your Lordship. Lordship, it will be General Manager LREs, respondent number 2. Or respondent number 3 can also consider.
Who is the third? 3? Because the letter is addressed to 3. So let page 22 be considered. This is a better drafting. Yes?
Yes, my lord.
Evidence of service. The petitioner.
Lordship, this can be considered, but the point is whether this has been received or not, that is not there because
My lord, the endorsement is there, my lord, at the bottom.
this
The endorsement is there. Yes. Yes, my lord.
this should not be received copy.
My lord, then my lord, page 21, my lord.
21, yes.
Yes, my lord, the endorsement is there, my lord.
Page 22 also there's an endorsement.
Yes, my lord.
The petitioner claims to be the recorded owner of the topic question and submits that the respondent authorities have initiated the process of acquisition of land surrounding the petitioner's land, for the purpose of mining operation.
Yes, my lord. AB pit open cast mega project.
For operation and completion of AB stop PIT mega project. And have published a notification to that effect. Stop. The petitioner submits that if the authority acquires the surrounding land, comma, the petitioner's plot which shall be left out shall become unusable and be damaged due to operation of the project. Stop. The petitioner submitted a representation before the concerned authority requesting the latter, LATTR, to, you want your land also to be acquired?
Yes, my lord.
The latter to acquire his land /purchase his land for the said purpose. Stop. The representation is yet to be considered. Representation on date 30th December 2020. 30th December 2020. So the petitioner pays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents that the third respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the third respondent
Not the third respondent or it's delegating.
Yes.
Delegating, your lordship. Because if the department is the land department, then general manager may depute and delegate.
যেখানে বললো না be directed to, ওখানে third respondent / his delegate.
Great.
Paragraph, in view of the above, the petition is disposed of, directing the third respondent / his delegate to consider and dispose of the representation dated such, filed by the petitioner, submitted by the petitioner, dated such and such, within 1 month.
But 2 months, because your lordship records, maybe, I don't know, records may not be available ready.
Within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of which?
And the representation, your lordship, the page 22, your lordship, the page 22 does not bear any date. Lordship,
Yes, the date of receipt is there.
Date of receipt is there, 28th.
So that's the date. 22nd December.
Grateful to.
Next.
Item number 8.
On my petition.
এই অমর কৃষ্ণ সাহা ছিলেন না, ওই জন্য এটা।
For the respondent number 4. My petition, my lord. I think today everybody is present, my lord. Well, this is a writ petition challenging the order of the competent authority as also the appellate authority.
Respondent number 4, you're appearing.
Lord, we are appearing for 2 and 3. 2 and 3, my lord, we are.
My lord, all are there today, my lord. Private respondent is also there and respondent number 2 and 3. This is the order of the respondent number 2 and 3, which is, my lord, subject matter of challenge.
We have a point of locus.
Well, let me start.
Let me
Let me start. my lord.
On locus.
on
Right.
Lucas.
Well, let me start first. Let me start, my lord, then your my lord will hear my learned friend.
I don't know. This is a preliminary point of objection, which I would also like to raise.
Well, let me first start. Your lordship will hear me. Then let me hear you.
This issue has to be taken up first in that case.
Well, I will show my locus also. And right now, my lord, I'm on a. I'll show your lordship, my lord, what has happened, my lord. My lord, here, my lord. This is the land, my lord, which belonged to one company called IOL, my lord. IOL owned the property, land, and my lord, they found, my lord, that the land was in excess. There was excess vacant land. So, my lord, all the formalities were carried out, and subsequently, my lord, they also applied under Section 20 of the Urban Land Ceiling Act for seeking exemption for the purpose of retaining that land. That order of exemption was granted in 1992. Pursuant to that order of exemption, they also transferred transferred that land to a company called ESAB. ESAB is the respondent number 4, the private respondent right now, my lord. It is our contention, my lord, that ESAB is violating the conditions of the exemption order of 1992. So therefore, my lord, the exemption order is to be withdrawn. That is our primary our case, my lord. Well, the exemption order provided that they will use the particular land for a particular purpose only and not any other purpose. Welding and welding of electrodes. They have stopped the factory. This is also an admitted position. So we, my lord, under the LUDCP, as also the land policy, my lord, once the land, it's a vested land, my lord. So exemption once withdrawn, the land goes back to the government. And my lord, under the LUDCP, as also my lord, the policy of the government, I being a neighborer, but I'm entitled to get that land also for purpose of expanding my industry. So I, my lord, made a representation before the department, my lord, for cancellation of the exemption order, withdrawal of the exemption order, and thereafter, my lord, to give the land to me by following the due procedure. My representation was not being considered. So I came before this honorable court. 8th of November, 2019, my lord, this honorable court passed an order permitting, my lord, page 225, permitting me to be, my representation to be considered by the competent authority. My lord, page 225.
Yes.
So, my lord, by this order, I was permitted to make my representation before the competent authority. I went before the competent authority. In the meantime, my lord, what happened, my lord? There was a conversion proceeding also which was filed by ESAB for converting the land, my lord, the nature and character of the land. That conversion order had been allowed. So on the basis that the conversion order has been allowed, the competent authority felt, my lord, that my application is not, the withdrawal is not maintainable, and also found that I have no locus. I preferred an appeal from that order, and I went before the appellate authority. The appellate authority on the first instance, my lord, your lordship will take on 21st January, my lord, page 413, 21st January 2021, my lord, passed an interim order. My lord, page 413. January 2021. My lord, page 413.
Yes.
Well, only one submission. Before this, well, what had also happened between my between the order of dismissal, rejection of my representation before the competent authority, and this first order, my lord, ESAB had obtained a NOC from the competent authority, which was being used for the purpose of obtaining a sanction plan under the West Bengal Municipal Act, my lord, section 203. So they had obtained a NOC also. In that background, my lord, if your lordship takes page 414, well, the last 4 paragraphs, heard all concerned. Since the advocate of ESAB raised a different angle beyond the issues incorporated in the appeal petition, stating that the subject property does not include any excess vacant land, he was directed to submit a written statement justifying his claim at the earliest. Next paragraph, my lord. The competent authority, SDO Barakpur, be asked to confirm whether any NOC as mentioned by ESAB has been issued from his end, and if so, a detailed report showing the basis of issuance of such NOC be submitted to the UDMA department at an early date. The department authority would examine the
matter and offer views in this regard. Malad, this is the NOC on the basis of which sanction plan they have applied. Malad. Second, let ULC branch UDMA department be asked to inform whether any prayer for change of purpose from welding business and ancillary, as mentioned in the previous exemption order to ISAB, to industrial park, along with DPR of proposed project duly vetted by MSME department, has been received and duly examined. Well, next paragraph. On getting written statement from ISAB and report from CA Barakpur and ULC branch under UDMA department, the matter would be heard again. So, my lord, in these last two paragraphs, my lord, the report as to whether that NOC has been, why it has been issued, on what circumstances it been issued, department to be given a report, and second, my lord, the change of purpose, whether an application. So once the department gives these reports, only after that hearing was to happen, my lord. My lord, this order of 21st January 2021 was made over to us, my lord, only after 16th April 2021. My lord, your lordship will see page 412. At 412, your lordship will find, my lord, the department, the appellate authority is writing to us saying, with reference to the above, I am directed to inform you that the hearing will be taken by the appellate authority at 2 p.m. on 19th April through video conference. A Zoom link was given also. So when we received this notice on 16th April, my lord, on this very same date, page 415, my lord, the lordship takes 415, we wrote to the department saying we've not yet received the order of 21st January. We were there at the hearing, but the copy of the order had not been made available to us. So, my lord, we write saying, please make over a copy of the order so that we can consider that order. So the order was given to us after 16th April 2021. And then, my lord, on 19th April, the hearing happened. On 19th April, my lord, neither of these, my lord, if your lordship, my lord gives leave for my senior to take over, my lord.
I'm sorry, I think we need to continue some other date because mentioned matters have been taken up from 12th.
I will not take more than 5 minutes to.
Wait.
I will not take more than 5 minutes. My point is very short. Lordship had seen page 413.
Yes.
Lordship has seen page 413. Lordship, at 414, last 3 lines, the Mukherjee has placed, but I am stressing on this, last 3 lines, on getting written statement from ISAB, and 414, last 3 lines.
Yes.
The 3 directions are there. On getting written statement from ISAB and report from Competent Authority Barakpur and ULC branch under UDMA, the matter would be heard again, only after getting these reports. Now, we get the order late, that's a different matter, but we submit a note where we point out that these records have not yet been submitted. Till the records are submitted, the matter is not to be taken up for hearing. So my point is as short as this. On the 19th of April 21 was not the due date for hearing. The hearing was fixed only after these records are made available. Lordship kindly sees page 431. Third paragraph, in response to the allegations made by so and so, the ULC authorities in UDMA inform that since no such proposal for change of business purpose or initiation of new projects were received from ISAB, and they were reported that ISAB has stopped functioning from so and so, one notice dated so and so had been given, what was issued so and so. Now, Lordship kindly comes to this next paragraph. The last 5 lines of the penultimate paragraph at page 431.
Yes.
Or may I place that paragraph? As in the appeal petition received on 18th February, the appellant countered the stand of ISAB that IOL had mistakenly taken exemption under section 20 of ULC. And as in the last hearing dated 21st January, the advocate concerned on behalf of ISAB claim that they have obtained one NOC from CA, from competent authority and SDO Paragraph 4. That relaxes the provisions of excess vacant land. The authority concerned in the UDMA sought report from CA and SDO regarding issue of NOC towards excess vacant land. The department officers informed that the reports of the competent authority and SDO are under scrutiny of the ULC authorities. The report not submitted as per paragraph, as per page 414. 414, the report had to be submitted only thereafter. So my point, I'm confining for the time being because the matter was to be heard after these reports. The matter was taken up without these. So, this is not the due date. I'm covered by several judgments. If there's an order of court, if your lordship passes an order today, that I will take up after the report is given by some authority, and I'm keeping it, and I'll hear the matter after that. The matter comes up before the report comes, and I point that out. It's not ready for hearing. The court is bound by the previous procedural direction, unless some reasons have given that report is not necessary or some subsequent event. So my submission is not, this is not ready for hearing on that date. None of these reports had come, and the matter couldn't have been taken up for hearing. Lordship, since Lordship has said, Lordship, my matter fixed up. Lordship, can I request, because the only difficulties from our side is that this is troubling us before another appeal, because in the section 4C appeal, this order is also coming in the way, and that is fixed on Friday. Like, may I beseech my lord to keep it tomorrow or day after, any time, if it's possible. I would like, well, I have finished. I will just take 5 minutes to cite around to authorities. Lordship, if it can be 5 or 10 minutes tomorrow or day after, Lordship, kindly, I am making that request because Thursday, my lord. Thursday, when Lordship, in the morning itself.
The morning itself.
Very, I will be. We shall be there.
Heard learned counsel for the petitions. Paragraph, let the matter appear under the same heading for further consideration on Thursday. Thursday is 31st. 31st August, fairly at the top.
Fairly at the top.
They are saying that Friday matter is there. Just now said.
No.
Now they are saying that they will not do the matter on Friday.
Item number 19, my lord, for the petition.
194. Mention matters from 12:30.
Mention. Yes.
Or 194.
Our difficulty is without notice they have mentioned the matter.
Who is appearing for the petitioner? None appears. Anyone for the petitioner? Council Derek on mentioning is it? What's the mention for us? Petitioner mention for us. This is so default. No one appearing. They mention and then they do not appear.
Our difficulty is, my lord, the serial number one, all the briefs will not come, my lord.
197. It's wrong, mention matters. Anyone in 197? First date. First date, this is for. First date to the. None appears for the petitioner, no accommodation is sought. Paragraph, let the matter appear under the same heading in the monthly list of September. 197?
197.
Please, please.
Just blood.
Have you served?
Not that. But I find, my lord, that affidavit service is there.
The state and the mineral development.
Yes. This is with respect to pertaining to, my lord, issuance of short-term mining license.
Service, because I do not find anyone appearing.
Lord, takes it up next week, my lord. I'm sure,
I'll
my
give
lord,
you a
that is so.
Since service upon the respondents is not complete, comma, let the matter stand over till 14 September.
Okay. Great.
May it please, Lordship, this is my application. It's challenging the resumption order passed by, my lord, the land manager pertaining to, my lord, a plot of land at Bidhan Nagar. Not the affix, where's the affix?
Mr. Bandyopadhyay for the state.
But the order impugned is at page 157 of the writ petition.
(157)?
Yes, my lord.
Yes.
And may I place the same? And on the second page of the order impugned, which is at page 158, and whereas it reveals from inquiry report dated 18th of November 2021 that the plot is lying vacant. Now, therefore, undersigned is on the behalf of the governor of West Bengal directed to say that the governor of the state of West Bengal pleased to resume the demise plot AC 87 in sector 1. And the lease deed is of 17th of June 1970, my lord, in terms of clause 4 of the lease deed. Now, my lord, I'll indicate what are the brief facts as to why, my lord, no construction could be carried out. But in 1970, this plot of land was allotted to one Mr. Ranojit Biswas. Thereafter, my lord, in December 1970, he took over possession. In 1973, my lord, Ranojit Biswas died. And my lord, in 1987, his only widow, my lord, Mrs. Biswas died also in 1987. Subsequent thereto, my lord, they are not survived by any direct lineal descendant. I am, my lord, the brother's son. And I, along with, my lord, the petitioner number 2, we approached the respondent authorities for the purpose of obtaining mutation. Those mutation proceedings still date are pending. That's why, my lord, I could not apply and obtain a sanction plan for the purpose of construction. So these documents are there. My lord, the first letter by which, my lord, they called for construction on the said plot of land was addressed to Mr. Biswas. My lord, page 35 of the writ petition. It is admittedly still in my possession, despite of which, my lord, they have issued the resumption order.
Period of construction.
My lord, in the original lease, it was 3 months. in 1970. Malad, the initial order communication is at page
Years from the date.
3 years, Malad, 3 years.
Date of possession.
Yes, Malad. Possession is in December 1970.
Was alive. for
Yes,
3 years.
yes. And construction was not carried out. Upon the demise of the lessee, I am in constant communication, my lord, from pages 35 to pages.
Later, subsequent. What about the original lessee not?
Original
constructed?
lessee could not. My lord, I cannot improve on that. And my lord, there was no resumption then. Resumption order has come in now in 2023.
So you're only asking for mercy.
My lord, today, my lord, if no, because in the event, my lord, my mutation is permitted, only then can I apply for a sanction plan. Without the property being mutated in my favor, I can't go in and have a sanction.
These are all subsequent events.
Yes, my lord. These are subsequent events, not with regards to resumption. It may be subsequent events with regards to the grant of lease. But with regards to resumption, my lord, since 91, they are aware that the original lessee and his only heir being the widow.
From the authority,
Yes, yes.
where is the information?
My lord, information is here. What you will kindly see. My lord, at page 40. Several communication. In fact, my lord, I'll place all of these communication for your lordship's consideration. Page 35 is the first communication with regards to, my lord, this plot of land from the Assistant Secretary of the Government of West Bengal. Whereas by a deed of indenture executed between the Governor of the State of West Bengal and you, this is addressed to Mr. Ranjit Kumar Basu, but by then he had expired. At page 35, my lord.
Yes.
Whereas by, well, this is issued by the Assistant Secretary of the Government of West Bengal to Mr. Ranjit Kumar Bishas, the original allottee. And Miller, on that day, he had already expired. Whereas by deed of indenture executed between the Governor of the State of West Bengal and you on such and such, a plot of land being number 87, block AC in sector 1 of Bidhannagar has been leased out to you on the terms and conditions as set forth in the said deed for the purpose of construction of your dwelling house. And whereas the delivery of possession was effected on 11th of December 1970, vide possession certificate dated 11th of December 1970. And whereas in terms of clause 26A of for the said indenture, you were required to construct your dwelling house thereon within 3 years from the date of taking over possession as per building rules. Thereafter, it is not legible. And whereas you have failed to construct, that was the intent and the purpose of the letter. Now, my lord, at page 36. This is dated, my lord, in reply to the earlier letter, 2nd of December 1991. This is dated 2nd December 91 in response to the letter which I just placed at page 35. What you will kindly see. I beg to inform you that the letter referred to above, addressed to Ranjit Kumar Bishas, has come to my hand. I am searching the deed as mentioned in your letter, and in the meantime, I request you to let me know what steps should I take in this matter, as in spite of our earnest wish and requirements of the family of residential house could not be constructed due to the aforesaid death. In this circumstance, I most humbly request you to allow me to construct a residential house in plot number 87 in block number AC of sector 1, Bidhannagar, without resuming the said leasehold land. And due to that unfortunate mishap in our family, till today, we have no residential house of our own. I hope you will kindly appreciate and consider this matter. So since 91, they are aware. It is not that they have come up today. Since 91, my lord, till date, they have continued to have this knowledge that there has been no construction and we have tried. My lord, page 37, this is in response to my letter, which has been issued, my lord, by the State of West Bengal to the petitioner number 1. I am directed to refer to your letter date 2nd of December 91 on the above subject noted, and I request you to submit to the department the following papers for consideration of your prayer. An affidavit to be affirmed by you before a first-class magistrate notary public as one of the legal heirs of late Ranjit Kumar Bishas, original lessee of the above mentioned plot of land, stating therein the following: name age and address of all the legal heirs of the deceased lessee and their relationship with him, whether the deceased lessee died intestate or left any will, whether mother of the deceased lessee predeceased him or is still alive, whether he left any landed property other than the plot of land in Bidhannagar, whether his legal heirs possess any other legal landed property in any urban area. Affidavits under Urban Land Act to be affirmed by all the legal heirs of the deceased lessee separately as per the pro forma enclosed. A relationship certificate from the officer not below the rank of the Assistant Secretary to the Government of West Bengal or subdivisional officer civil stating relationship of the deceased lessee with the legal heirs, death registration certificate. We submitted all of this. Well, the difficulty arises after this is that even despite of submission of all of this, well, the mutation has not been granted. What shall kindly see at page 58. Now, there's been exchange of correspondence from 37 to 55. The several correspondence. It is admitted possession. At 58, my lord, it's a communication which we have had with the officer on special duty. May I place the same? My lord, this is dated 7th May 2002. My lord, so for the entire period of 10 years, my lord, we are constantly in communication. This has reference to your letter dated such and such, dated 4th of September 2001, in reply to my earlier letter dated 19th April 2001, requesting me to submit papers listed in your letter under reference and also your last letter number such and such dated 30th of January 2002. In this connection, I like to inform you that I have already submitted the following documents in compliance of your earlier requisition dated 27 March 1992 and 2nd of April 1992, video my letter dated 21st of August 1992. For your kind ready reference, I endorse a photocopy of the said letter. Regarding the right of inheritance to the estate of the deceased, the law is very clear. Since the deceased Ranjit Kumar Bishash allottee was my full-blooded brother and his wife have died. In the meantime, and having no issue, the estate of the deceased shall devolve upon the following persons. That is, my lord, the petition number 2, then Dr. Devojit Bishash, Ms. Shrimati Taposhi Ghosh, and Manoshi Kaur. Certificate of heirship in this regard has already been submitted via certificate number 6, dated 6th May 1992, issued by Dr. Ranjan Roy, by Mr. Ranjan Roy, Judge, 24 Parganas, First Special Court, Alipur. Photocopy is enclosed. The suggestion is according. Succession, my lord. The succession is according to the Ayavagha School of Hindu law to which we belong. Therefore, affidavits of legal heirs of late Ajit Kumar Bishash, late Ashit Kumar Bishash, and late Shukava Roy are not required at all, and the aforesaid deceased persons are my full-blooded brothers and sisters. The sons and daughters of my deceased brothers are all my nephews and nieces, and they are not legal heirs of the estate of the deceased Ajit Kumar Bishash. Regarding clause 5B, it is confirmed the deceased person all died intestate. Regarding 5C, it is confirmed that other than the plot in Bidhannagar, the deceased did not leave behind any other landed property, and it is so in the case regarding 5D, mother of the deceased Ranjit Kumar Bishash. In terms of clause B of your letter under reference, we have deposited rupees 500 in the State Bank of India at Bikash Bhavan, Salt Lake by a challan bearing number TR form number 7 in the head of account 0217 urban development -65 other development scheme should be under development scheme receipt number such and such for mutation of the plot of land in favor of Manojit Kumar Bishash and Dr. Devojit Kumar Bishash. The receipt showing such deposit is annexed. Now, the receipt is at page 61 and 62. This is of 2002, my lord. The next communication is at page 63. This is after a lapse of almost 10 years. This is again 15th of March 2011. And addressed to the said deceased Ranjit Kumar Bishash. Despite having communicated with us, indicating that this is the position, and we having intimated to them that the said allottee is no more alive, they proceed to communicate with him. This has continued to go on. and we have applied for mutation. My lord, the form has been filed, but without the form, without mutation being granted, my lord, there cannot be any construction. So, my lord, these circumstances, despite having full knowledge of the fact that we have applied for mutation, there has been the change in the. We have requested the relevant authorities for the purpose of recording our names in the revenue records. No, they did not proceed to do that, and accordingly now they have come up with the resumption order. And it is not that today they are seeking resumption; they have sought it before. We have complied with those directions. We have put in the documents. They know that we have applied for mutation, but today they somehow they come up in 2022 and seek a resumption again. But this is 2021. Where we applied, therefore we came up before your lordship, my lord, from 1991 to 2021, my lord, if they have not done it, and today I want to construct, and there is because I have applied for mutation, I want to construct. Well, if they resume the land, I'll be without any chance of having any, my lord, residential house. That is all, my lord. Today, if they want to.
Yes, sir. Last directly to submit report in the form of affidavit.
Copy.
Have
you made over a
copy?
No, my lord.
No, my lord. Just now I'm handing.
বলছি ওটা possession into possession. They put up a that's the order filter now. কিছু কানার মতো এগুলো করে দেয় হ্যাঁ কিছু করিনি করবোটা আছে তাই তো দিতে হবে they seem to have taken possession, but which is quite surprising because, my lord, I believe there's already an order which is subsisting.
Yes, Mr. Bandhavadi. You have received the mutation application not considered.
My lord, it is not possible as per the government circular. They are not the direct blood relation, my lord. As per government circular, they are nephew and niece.
Then they should have indicated instead of asking for documents constantly.
Even a reply to the
My lord,
that is still pending.
That is pending.
That we can, my lord, your lordship direct, my lord, we shall, my lord, inform them. But it resumption order has been not taken, my lord, possession has been taken.
No, possession, my lord, I'll indicate. There's an order of 28th of November 2022 when it was not indicated that they have resumed possession.
The year 1969 in favor of Ranojit Kumar Vishwas.
In 22 when the matter was taken up.
They have not taken any step in spite of, my lord, taking possession.
Well, and what about the conduct of the state? That I apply for mutation, they call for documents and they do not do anything about it.
What was the lease agreement?
Well, on 28 November 20, there is no dispute about that. I'm only on this. Well, then on 28 November 22, not for once did they come up and tell your lordship that yes, it's been resumed. So obviously it gives presumption that there is something which is doubtful about the conduct of the state. You'd like to use an affidavit, my lord, dealing with this report.
That you can.
Why don't you come back with an exception?
We'll take an exception. My lord, in the meantime, I'm only praying, my lord, since they have taken possession, they shouldn't, according to them, according to us, they have not taken possession. According to them, since they have taken possession, they should not give it out to any third party. It will entirely defeat my rights, my lord.
They have no right at all. They are not the direct blood relation as per the
Well,
government.
where he am.
148
Third party.
Yes.
The matter is disposed of.
in the meeting.
Report in the form of affidavit submitted on behalf of the state respondents is taken on record.
My lord may indicate for certain limited period. To that effect.
Yes, yes. Yes, yes, I have no problem.
It's not a very long matter. It can be disposed of in the meeting.
Yes.
That is. हम डिस्कस करी दो एप्लीकेशन तो ये तो जतिए दो ये तुम्हारे इधर में होगा
It is contended on behalf of the petition.
My lord, your lordship may, my lord, instead of the direct the authority concerned to take a decision to the mutation application within a certain period of time. That will suffice, my lord.
That can be done. Till then, there will be no.
And it will be
third party.
communicated to the.
And my lord, I'll be given the liberty to take exception to the report. Because your lordship's previous order says specifically status quo with regards to nature, character and possession of the property. That is surprising because then the submission should have been made that we have taken possession. That was never made to court.
There was an order of status quo. Yes.
Yes, my lord. 28th of November 2022. Sorry, my lord, that's the. Well, this is dated 25th January 2023.
It's already there. So you don't,
Yes.
you don't require a further interim order in that case.
Well, but status, since they have resumed possession today, they are saying this is prior to there too. Because, my lord, on that day, they should have indicated that they have resumed possession if they had. Today, if they go ahead and create a third party right, even if they execute a lease deed, it will be.
His writ petition has been filed after taking possession, my lord. It has been affirmed, my lord, on the 13th June.
That is the surprising part. I have
13th
challenged it.
June 22, but possession
And
has
they
been
say
taken
that it's
after
been,
taking
possession has been taken before that.
You have given the report. That is unacceptable.
That is the surprising part.
Page 11.
They have, and the state is.
Last 50 years, after taking possession, they have come before this honorable court.
State is so proactive today that on the date of issuance of the repossession order, they take repossession.
My lord, may better merit your
Yes.
direct the authority to dispose of their application, mutation application.
But I would like to take an exception because
He wants to file an exception to this.
I have to take an
Let
exception.
him come.
Might come.
It is contended on behalf of the
Down.
petitioner that one Ranojit Kumar Bishwash, since deceased, was a lessee in respect of the plot in question by virtue of deed of lease executed by the state of West Bengal on June 17, 1970. Possession of the property was made over to the lessee on December 11, 1970. Stop. The lessee expired on August 10, 1973, and his wife also expired on March 6, 1987. Stop. Since the couple was issueless, the petitioners, how are they related?
My lord, the petitioners.
Page 148, your lordship, kindly turn to page 148.
Petitioner is the son of the full blood brother, Monojit Bishwash. Monojit Bishwash, in the meantime, also died, I believe.
By the page 148, their mutation application of the writ petition. Table, my lord, there, Satyajit Vishwas, Bandana Vishwas, nephew, niece, sister-in-law.
The petitioners who are the nephew, comma, nieces and sister-in-law of the original lessee filed an application before the concerned authority for mutation of their names in respect of the plot in question in order to enable them to raise construction therein. Stop. There were several communications made by the petitioners for the concerned authority ventilating their desire to raise construction in the said plot, which was not possible until their names were mutated. Stop. By a letter issued on 22nd December 2021, the land manager, Vidhannagar, Department of Urban Development and Municipal Affairs, Government of West Bengal, informed the petitioners that the authority had resumed the plot in question by cancellation of the lease deed and directed the and requested the petitioners to hand over peaceful physical possession of the plot in favor of the authority. Stop. Said letter is assailed in the repetition. Stop. Paragraph. Learned counsel for the petitioners submits that despite an application seeking mutation of the property in favor of their in their favor being pending, the authority chose to terminate the deed of lease unilaterally without affording an opportunity of hearing to the petitioners. Paragraph. Per contra, learned counsel for the respondents submits that possession of the property has been taken over by the respondent authorities in terms of the letter issued on 22nd December 2021, that is, prior to filing of the writ petition. Paragraph. Learned counsel for the petitioners seeks to use an exception to the report in the form of affidavit submitted on behalf of the respondents. Paragraph. Let the matter appear under the same heading on 8th September.
Lordship. So in the meantime, they'll not.
Advance copy.
Yes, I'll serve an advance copy.
Paragraph. The state respondents are restrained from creating any third party interest in respect of the plot in question. Till 30th September 2020.
I'm great.
I beg pardon to my lord. My lord, I could not appear, my lord, 194, 195, 196. at the time of call, my lord. I missed the list, my lord. Kindly pass it over for the day or take it on Friday.
This is for default whereas.
I can remember. 194, 195, 196.
You mentioned matters.
I know that I missed the list, my lord. I am running with fever. So kindly, I mean, from the other side, kindly take it on Friday.
I'll just make it not today. 194, 195, 196, not today.
Not today.
Yes.
My lord. Not.
Yes, 199.
My lord, I am for the petitioner, my lord.
I made an application for addition of party. Last occasion, your lordship heard the matter.
My lord, I have no objection. Their application may be allowed. Unauthorized construction on the government, my lord, on the government land. The DM is the authority. Let the DM my lord, kindly direct the DM to decide
My lord,
the matter.
I have to passing that order. I have at the point. My lord, if your lordship allow
Give me a
me.
minute, please. Give me a minute. Who is appearing for the state?
Last occasion, somebody appeared. I have given.
Can 1 of 2023 is your application?
Yes, my
yes.
application for addition of party because we are.
My lord, I have received it.
We are the lessee of that plot of disputed plot of land.
You are the lessee.
My lord,
My lord, I am appearing on behalf of the respondent number 9 and 10, my lord.
my lord,
My lord, may I submit one thing, my lord?
Ms. Sweta Mukherjee and Mr. Rahul Das.
Yes, last occasion, 2 occasions they have appeared.
Where are they? Are they still in the panel?
my lord,
Ms. Sweta Mukherjee and Mr. Rahul Das, are they still in the panel?
my lord, yes.
You have no knowledge?
No, no, new matter. Sita Mukherjee and Ratul.
I have served copy to them also.
Shweta Mukherjee and Rahul Das.
Let me allow the application today. I'll fix a date for the writ petition.
My lord, it's a very simple thing. They are, my allegation is.
State. I do not find the state. Please inform them.
My lord, may I submit one thing, my lord?
Yes.
My lord, kindly come to the page 15, annexure P2 of the writ petition, my lord, where the writ petitioner specifically stated in. My lord, kindly come to the third, yes, page 15.
Yes, yes.
My lord,
50.
15, annexure P2. Their representation.
Is not the representation.
15 of the writ petition.
15 of the writ petition, my lord.
Yes.
My lord, come to the third paragraph. May I read, my lord? ভীমপুরে আমার অনুপস্থিতির সুযোগ নিয়ে বড় ভাসুর শ্রী প্রমোদ রঞ্জন মণ্ডলের নিষেধ সত্ত্বেও তার ছোট 2 জামাই শুভজিৎ বিশ্বাস সরকারি চাকুরে সন্দীপ বিশ্বাসের প্রত্যক্ষ প্ররোচনায় ও মদতে আমার বাড়ির সামনে পিডব্লিউডি ওদের নামে লিজ থাকার মিথ্যা অজুহাত খাড়া করে ওদের বাড়ির সামনে পিডব্লিউডির জমি থাকা সত্ত্বেও ওই পরিবারের অন্যান্য সকলে মিলে বেআইনিভাবে বল প্রয়োগ করে আমার বাড়ির সামনে পিডব্লিউডির জায়গা দখল করে অবৈধভাবে ঘর নির্মাণ করেন। I had no allegation against the respondent number 9 and 10. And another thing is, my lord, very tactfully, writ petitioner did not mention who constructed or erect the construction in front of the writ petitioner house.
My lord,
Because let me kindly conclude me. Kindly conclude me.
Here before your last page 22 of my application, the list, the document, record of rights shows it is our.
my lord, I am assuming but not admitting. They are saying they are the leaseholder. My lord, kindly come for a moment in my writ petition.
I don't think I can take up the application in absence of the state. Let the state come. Please serve a notice to them.
My lord,
I'll allow your application because
my
you have no
lord, I
objection.
have no.
My
Can, you know. The applicant / intervener seeks to be added as a party respondent to the petition on the ground that
ডাউন করে আমার ক্যান্ডেল তুমি যদি বড় কষ্ট আইটেমে তাহলে কিন্তু
এক আর তিন
আগের দিন লিখে আমরা কেটে দিই
they are lessees
আগের দিন
in respect of the plot in question and
অ্যাপ্লিকেশনে
any order passed in the petition is likely to affect their interest. Paragraph
আর দিন কিন্তু মারা গেছে কষ্ট আইটেম কানেক্ট করে তাহলে আগের দিন
কবে
paragraph, learned counsel for the petitioner
লিভ গ্রান্টেড কবে
has no objection if the
Leave copy.
application is allowed. Paragraph, in view of the fact that the intervenors, applicants intervenors claim to be lessees in respect of the plot in question, comma, they are necessary and proper parties to the writ petition. And the petition is required to be considered in their presence. Paragraph, in view of the above, the application being can 1 of 23 is allowed. Paragraph, the cause title of the writ petition be amended accordingly. Urgent certified website copy. There shall however be no address to cause. Urgent certified website copy. WP the order. None appears for the state respondents. Paragraph, let the matter appear under the same heading on 15th September. 15th September. Paragraph, the petitioner is directed to serve notice upon the state respondents intimating the urgent date.
grateful to you.
My lord, I can, my lord makes it not this week, my lord.
Later.
Item number 219.
You want to file exception? Who is appearing for the respondents? No, hang on. Report is submitted today. Report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph, learned counsel for the petitioner seeks to seeks to use an exception to the report. Paragraph, let the matter appear under the same heading on 12th September. Please serve an advance copy. Oh, this is affidavit of compliance, right?
What is September?
Report in the form of
220.
affidavit of compliance.
Submitted on behalf of-
Alleged contender. In 220 and 221. Very well. 220, 221 affidavit is submitted.
এটা থেকে যে রিপোর্ট নেই
19 and 21. Yes, the same is here. So let the same order be passed. Please file the report. Yes, I can find your name. Yes. Where is your exception? Ready? Served. She has not come to court.
Yes.
She has not come to court. But can it be taken up in absence of the authority? Because they are the answering respondents. It's difficult. Yes.
On the basis of that report, whether they are not taken.
Yes, what is the matter about? Please tell me.
Deputy Lottery Vision operator of the industry on the expected to. And a permit account to Gusta. Permitting authority the SP status of to attend. For sometimes in the year 32, this permit was issued. There are around 6 occasions. The permit as well as the timetable has been countersigned by the authority, by the SP factors. That is the responsible 3 years. Well, the timetable is the condition precedent of the permit. But along with if timetable is the type to permit, there is no value of the permit. Along with the permit, the timetable has been issued. Incorporating 1 point that has been countersigned successively by the state till the last Now we are going to kindly come to the picture.
Yes.
Page 30 is the last counter signature issued by the state Jharkhand. And first party page 21 is the party of 2002. Philosophy comes the first page 21.
Yes.
This is the party number 03 of 2002. Both file access to Dunka, Aya Damka, and this is the service. Now, along with this party, time page 25. Page 25. This has been countersigned. But when the permit was issued, the permit was issued, there was an agreement between state of Bihar and state of West Bengal. That agreement of 1980. According to that agreement, the permit was issued. But in 2001, after the reorganization of the state of Bihar, Jharkhand came into force in 2002. So my permit has been countersigned also by the STA Jharkhand after the reorganization of the state of Bihar. Like page 26 is the counter signature, the first counter signature of the ST Jharkhand. There are to be permit was renewed for a further period of 5 years. That permit has also been countersigned to the ST Jharkhand, page 27. In 2007.
Yes.
Thereafter, in 2013, page 29. In each every 5 years, when the permit of bank has been countersigned. There is a kind of coming to the page 30. This is the counter signature
Till 22.
Till 22. Well, you also kindly note that route by lot, Asansol to Dunka and point Bihijam, Jamtara, Bagdaha, Patali. All these points are included from the very inception of the grant of permit and the very inception of the grant of counter signature from 2002. Well, thereafter, what happened, my lord? This permit has been renewed. Page 32. Page 32 is that they are renewed. And from 1st September 2022, 31st August 2027. That is bottom line.
Yes.
To figure Asansol Dunka Jamta.
Yes.
Along with permit, renewal permit, page 33 is the counter signature time date.
Yes.
At the bottom, my lord, right hand extended up to 31st August 2027. Same time taken. No variation, no modification, no revision. Same time taken. Bihijam, Jamtara, Bagada.
Timings are also same?
Same. No change, no change. But what happened? There are the page 32. STA West Bengal in terms of the reciprocal transport agreement requested the STA Jharkhand to countersign this permitted time. Page 34. But 35, my lord, this is the counter signature. That is improved hearing. Well, this is the counter signature. You did Asansol to Dunka by Jamtara and this has been countersigned on 15 September 2022. Well, they are in the time giving page 36. They have started slow more to the point. Bagdogra, sorry.
It's only Asansol and Jamtara.
They have slow more to Katel Bagdaha and Protestant. First time.
Bihijam is also not there.
Bihijam is also not there. First time. Without sending any reason, without giving any opportunity of hearing, they are cut. And as a consequence, fellow, I am facing the unrest of the public. So all of a sudden, why you stop? Why is it stop your pass at least? Even why? I made objection. Nothing has been happened. I can give you your loss. Now your loss kindly come to the report. Report is always get filed.
Yes.
Only 2 paragraphs. Paragraph 5 and 6, only 2 paragraphs. That is not the state to submit the status of this Jharkhand has taken a decision in the meeting dated 31st January 2019 the timetable will be sanctioned only according to via mentioned in the reciprocal agreement. And this says,
Yes.
well, provided that Mr. by later than 3rd March 2023, I claim the individual also produce these letters at the time. No letter has been sent by. No letter has been sent.
You want to go through this and come back? All throughout you have issued a particular timetable. Suddenly you curtail it by
It has been 5 years. The route will be decided on that. And the 21 years.
you've annexed the decision with your report. Then if it is a policy decision, you have to annex it to your report.
What a policy decision, thereafter they have deviated from their they themselves deviated. And what is that?
In case of other vehicles?
Yes, my lord.
Have you filed the document?
Yes, I have.
Let her go through the exception and done.
Only point that they will time according to fire. What is fire? Fire is alignment.
Exception used by the writ petitioner is taken on record. Paragraph. Copy of the exception is made over to learned counsels for the respondents in court this day. Paragraph on prayer of the third respondent, the matter is adjourned. Paragraph, let the matter appear under the same heading on 15th September. No, come back on 11th. 11th, no?
Item number 203. 23.
223.
23.
Petitioner?
Can we dispose of our directly already concerned to consider relates to document of rent from the last quarter of 2000. Let them see together, take a decision.
Yes. Where is your representation? Where is your representation?
That is your paragraph 23. Sorry, page 23. That is true.
Why don't you file a comprehensive representation before the authority? I'll grant you liberty. The petitioners are joint owners of the property in question, which is a multi-storied building comma, a portion of which has been leased out to the respondents by virtue of lease agreement in the year 1993. Stop. The agreement was renewed on 13th April 2005 and rents were enhanced with effect from 10th November 2003. Stop. Paragraph. The petitioners complain that the respondents have not paid rents from the last quarter of 2009 and several requests made by the petitioners for payment of enhanced rent or release of the property in their favor fell on deaf ears. Stop. The petitioners seek to submit a comprehensive representation before the respondents in this regard. Let there be a representation and deal with it. The authority can decide. Let the authority decide upon hearing the petitioner. Yes? In this regard, and pray for a direction upon the authority to consider the representation at the earliest. Paragraph. It is submitted on behalf of the respondents that who should consider? The general manager. Or the chief general manager. The general manager. That the third respondent be directed to the third respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the petition is disposed of with liberty to the petitioners to submit a comprehensive representation before the third respondent within 7 days. Within 14 days. Within 14 days from date. Stop. The third respondent is directed to consider and dispose of the representation within 1 month. Within 6 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to the petitioners, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioners within a week thereof. Disposed of which? That's recorded. Since no evidence.
Okay, disposed.
Item number 224.
Yes. You need some more time? Learned counsel for the respondents seeks extension of time to submit the report in the form of affidavit as sought. Paragraph. Let the matter appear under the same heading on 15 September.
Item number 225.
You are for the state? State has received a copy earlier. So you want to come back or are you ready today? Copy of the supplementary affidavit is made over to learned counsel for the private respondent in court this day. Paragraph. On prayer of the private respondent, the matter is adjourned. Okay.
Effectively, make it consider. Only that
Do you still need time?
The difficulties, my lord, earlier to file a case for the action on contempt applications, my lord, pending. So what happened to the contempt application?
Pending?
Yes, the section for the application. That is pending, not appearing. Itself not appearing. But the matter is.
Not appearing in the contempt application?
Not appearing. Just by mentioning, not appear. Did not appear. Did it.
So how can this be taken up on the same cause of action?
The same cause of action, but I have made after the present. Of that, this is what I mentioned that these are the improvements, these are the things of the court. And I try to get the imprisoned hard and dispose of it. That's the only way.
You want to come back still?
Make it work.
Not tomorrow, I'll give you a date. You are for all the private respondents?
No, I for the private respondents.
6.
So I saw 2 of them, they have seen.
You are for 6 only?
Yes.
It are private respondent number 6. On prayer of the private respondent, the matter is adjourned. Let the matter appear under the same heading on 12th September. 12.
Item number 226.
Have you received a copy?
Yes, I have received the copy. I have not get the same. I am paying for 3%. That is number page number 26. That is November.
The challan is at page 25.
Page 26.
26 is the vehicle search. $25 should be the challan. Yes, 25. Yes, Mr. Sen.
Earlier better. Saying that here there is some difference. Here was kindly come managed page 20 of the need.
Yes.
Right hand side, cross vehicle right. This is the copy of the registration certificate. Now,
Yes.
Needed weight slash gross vehicle weight 47,500.
Yes.
Now when it was
Sorry.
on to page
27.
28, 49,560. Now their contention is that in terms of this notification, annexed to the requisition itself at page number 16. Even after issuance of that notification in 2018, they say that explanation at the bottom. Explanation at the bottom. For the purpose of this notification, tolerance up to 5% is the gross vehicle weight shall be allowed. Very important one. It is not stopped there. Tolerance up to 5% for the purpose of this notification shall be allowed. Then, very important thing is, for the purpose of compliance to subsection 3 of section 113 of the motor vehicles. So, subsection 3 of section 113, in course of compliance of the same, if it appears that even in respect of the maximum gross laden weight, gross vehicle weight, after having been increased by this notification, suppose lordship right and from 3 ton, 7.5 ton, according to axle weight, even if it exceeds 5%, then also for the purpose of 130 within bracket 3, 5% can again be allowed. And in earlier matter, exactly my lord was kind enough to allow the same. Now let's kindly come to my lord 130 within bracket 3 of the act. It's because I just want to draw the lordship line attention to the distinction 130 within bracket 3 of the act.
Yes, yes.
No person shall drive or cause or allowed to be driven in any public place, any motor vehicle or trailer. Then A, the unladen weight of which exceeds the unladen weight specified in the certificate of registration of the vehicle.
Yes.
So, for this notification, it is being issued. Then whatever the unladen weight mentioned in the article, that is the final and that is to be complied. But in 2008, after this notification, this my lord, that irrespective of the registration certificate to whatever speaks, but according to the my lord, this notification, it is my lord allowed to some extent, my lord exceeded to calculate, but up to this limit. And 5% can be also allowed. It is according to. Now here what happened? Kindly consider one thing. Then my lord kindly come to clause number 2 of the notification.
Yes.
This is my lord. I am on this. Clause number 2. The gross vehicle weight shall not exceed the total permissible safe axle weight as above. As above means including everything. Whatever the my lord, the maximum which is mentioned there in the column, in the table, in 1, clause number 1 is the table. In the notification itself. So kindly consider this. In the notification at page number 16, serial number 1, 1.1, 1.2, up to 4, under the clause number 1. The clause number 2, if I read, the gross vehicle weight shall not exceed the total permissible safe axle weight as above, and in no case shall exceed 49 tons in case of rigid vehicle. This is rigid vehicle. In case of rigid vehicle, so whatever be the maximum limit in first part, that is, my lord, in respect of single axle 3 ton, single axle, single tire 7.5 ton, whatever. But gross vehicle weight shall not exceed the total permissible safe axle weight as above, and in no case shall exceed 49 tons. Here it appears that it is, my lord, the gross vehicle weight, my lord, came to 49,560 at page 28.
Yes.
So that means it is not permissible to carry the goods that comes to finally the weight, gross vehicle weight of the vehicle that comes to this figure 49,560. And in this case, that 5% extra is not permissible, because 5% extra cannot be beyond 49,000, because 49,000, it is, my lord, it is stated under no circumstances cannot be exceed 49,000. (49 tons in case of rigid vehicle).
But the explanation says that 5% relaxation can be given.
My lord, now, my lord, kindly read this clause 2, not independently. Read this clause 2 in a conjoint reading with the earlier part. My lord, kindly consider this. May I allow you to read again? The gross vehicle weight shall not exceed the total permissible safe axle weight as above, and in no case shall exceed 49 tons in case of rigid vehicle.
This is the general rule.
Yeah. So 49 tons is the maximum. Then my lord, kindly come to explanation. For the purpose of this notification, tolerance up to 5% in the gross vehicle weight shall be allowed for the purpose of compliance to subsection 3 of section 113. So restricted to subsection 3 of section 113. Now you are again kindly come to subsection 3 of section 113. It speaks about in comparison with the whatever, my lord, it is mentioned in the certificate, and my lord, the actual load of the, my lord, the vehicle. So these 5%, my lord, cannot supersede that, my lord, that the maximum limit of 49.
That is not the explanation. I'm sorry, Mr. Sen. I do not agree with you. I do not think that is the explanation.
But
49 is the general rule. 5% relaxation has been granted on that.
First thing, Lordship, kindly the first table.
I've seen that.
First table is there. That single axle with one single tire, and then in this way, this is going on. They say that maximum gross vehicle weight shall not exceed total permissible safe axle weight more than 49 tons in case of rigid vehicle.
That is the rule.
That is the rule.
But 5% tolerance of the rule is allowed. That is the explanation. Explanation to the rule.
5% tolerance subject to 49 tons.
No.
Consider because previous to this, I will try to see here. If otherwise, the respective maximum latitude is mentioned there. And then again 5% this again, because in all earlier cases, this is below 49 tons.
It's the same. The general principle is explanation and relaxation is given only on the fixed weight given in the rule. It cannot be inclusive of the rule. Then there is a relaxation that is beyond.
Relaxation means.
5% relaxation.
Relaxation means that what is the my lord the, this is not subjective but objective.
Yes.
It's some on the basis of some object. Now,
Yes.
relaxation way it is specifically mentioned because my lord any relaxation cannot negate the entire my lord the earlier clause of the notification. So can you consider where it is mandatorily mentioned there it shall not exceed. This is the maximum limit. Then that means my lord it has no meaning of this 49 tons maximum. Can we consider this aspect also?
That's all your submission. I'm sorry, I cannot agree with you on
I
this.
think the logic, but my lord, and on the basis of this, my lord, that challan was issued.
Yes.
That irrespective of the fact that this notification was there,
I'll record your submission.
and here, my lord, that nothing has been slapped upon.
No, he has not paid the penalties. Yes. Only the challan has been issued. Yes, there is an amount.
No, amount mentioned there.
And I think the
But
petitioner
I-
is challenging only the overload part. There are three issues. Yes. You are only challenging the overload part.
And there is another issue, the national party, but they have violated one of the terms of the national party. But this is not. such-
Petitioner is not challenging the other 2 points, I'm sure.
Challenge the intent. Challenge the intent because Malak, I have the having national party.
National party, but it's up to avoid the. No, violation, yes, I have stated here.
Only one paragraph. last paragraph.
Section 66 violation.
Yes, paragraph number 4. Paragraph number 4, last line at page 2 at the bottom. Admittedly, the GPW noted in the said OMH scheme was 49,560 kg further. The said vehicle did not comply with terms of national parking for not being attached or tagged to reflective text properly. One of the national parking reflective text are being shown on the vehicle itself. It was not shown properly. And this is one of factual aspect. Now he can rectify the same. And he has not denied the same. He has not denied the same by way of fighting injection.
Vehicle is flying without permit, without documents.
Do you want to come back with an exception?
Very much a plan, my objective is better than
Because I was under the impression that you're challenging only the excess load part. So since you're challenging all the 3 counts on which the fine has been levied, you have to substantiate your case. Because this is a violation of section 66.
66. But all the documents produced. Now the authority is saying that no, you have not produced the document.
Have you stated that in your writ petition?
Yes. I have stated.
If you want to use an exception, I'll grant you liberty.
The page 6, paragraph 7, last line. Though the petition has obtained permit from the concerned authority. Paragraph 6, 7, I have stated.
Wants to find an exception. Denying the same because of the affidavit.
That's why I'm saying, since it's a report in the form of an affidavit, if you want to file an exception, I can grant you liberty. Report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph learned counsel for the petitioner seeks to use an exception to the report
for this one, but another one was internally recorded. What is that one?
There is an affidavit. There is you file an exception with regard to the entire affidavit.
It doesn't know that
Yes,
5% inclusive of all.
But it has already said it.
That is immaterial. That is immaterial. It varies from case to case. So it is always prudent that you deal with your case.
My contention is that this is different from that.
Yes, yes. So please deal with this issue also in your affidavit. File an exception. Let the matter appear under the same heading on 12th September. Yes, yeah, I have taken it.
Item number 227.
Yes. Mr. Sen is appearing in this matter.
Well, the home back agency jurisdiction, in any event, let him start. I think that.
The petitioner is a permanent permit holder. Now the route Howrah station to Tarokeshwar. Your Lordship will find at page 12 of my writ petition the permit.
Yes.
Now he made an application before expiry of his permit for replacement of his old vehicle by another one. Now that your Lordship will find at page 14 of my writ petition. This is important to say, it was made on 29th of January 2018. Now no steps taken by the authority.
Yes.
Now no steps taken by the authority in a demand of justice that has been made. The next page your Lordship will find by the advocate. And that is at page 17. Now then nothing has been done even. He moved before this honorable court. A direction considering his representation that has been given. The Lordship will find that the order is at page that is at
23.
Fine. Now, then the authority by a memo that is at page 25. Ask the petitioner to place the vehicle in place of the earlier one. The second paragraph of the this memo says that the vehicle should have been BS6 compliant with one.
Yes.
Now, very next page, he made a representation again. That is at page 27. But there he explained that this application for replacement was made on 2018. But in 2018, there was no BS6 compliant vehicle. But his contention was that at that point of time, he has to place the BS4 vehicle. Now, subsequently, when this memo was issued by the authority, that's in 2022. Now, the BS6 vehicles has come up. Now, his contention, he has to place a BS4 vehicle in that permit. Now, that representation has not yet been considered. Now, your Lordship can appreciate our situations has been changed. Now, some guidelines has been issued by the government in 2023. But your Lordship, I am facing one guideline that has been 2nd of June 22, others copies. Here, my lord, it has been specifically, my lord, আরেকটা কপি আছে আপনাদের কপি এখানে আরো কপি আছে কোথায় দুটো মানে I think মানে there are 2 copies মানে
Yes.
মানে দিচ্ছি now your lordship kindly come to my lord, these guidelines so far as this order that is of 2nd June 2023. Now your lordship kindly come to my lord, the third para thereafter my lord, registration and my lord, A, the registration and allied services. Now your lordship kindly come to my lord.
May I just take my other matter, already taken up. Only thing may I, if your lordship would kind enough to pass any order with regard to my lord consideration of his representation, so far the my lord the replacement of vehicle is concerned, then my lord I think my lord can pass that order. Then my lord within a certain specific period, let that be considered my lord by the concerned authority, my lord.
In terms of the.
This notification, so 2nd June.
In the light of this notification.
Yes. That your lordship will find that so far as this, your lordship will come to page 2.
Your route is beyond CBD.
Not only that, my lord, page 2, your lordship kindly come to page 2 of the said, my lord,
You've
notification.
given me another copy.
My lord,
Eta ফেরত দিয়ে দিন। Another
there are
copy of the
3.
same.
Whereas, my lord, 2nd June, huh? Devo. So, your lordship kindly come to my lord, the page 2.
Yes.
My lord, it starts, my lord, this heading is of page 2, your lordship will find Roman 3. In Roman 3.
Yes.
In case of inter-regional routes having its originating terminating point in the Kolkata metropolitan area, the vehicle to be placed in permit may preferably be a BS4 emission norms. So, my lord, this is this might.
Place
My lord,
BS4,
BS4.
I think my lord that would sufficient.
Yes, my lord, that on the basis of this. Mine.
May I leave?
Evident results. The petitioner is a holder of a permanent stage carriage permit, which is permit in the route Howrah Station to Tarakeshwar, which is valid up to which was valid up to 14th February 2018. Stop. The petitioner applied before the concerned authority for renewal of the permit
And the replacement.
upon replacement of the vehicle, existing vehicle by a new one. Applied before the authority যেখানে বললেন ওখানে on 29th January 2018 করে। 29th January 2018, 29, which not being considered, the petitioner came up before this court in a writ petition being WPA 3679 of 2022. Stop. By an order passed on 14th March 2022, a coordinate bench of this court directed disposal of the representation submitted by the petitioner with liberty to the petitioner. A coordinate bench of this court granted liberty to the petitioner to produce the new vehicle to the petitioner to produce the new vehicle as replacement of the petitioner's old vehicle in terms of the provision laid down in section 83 of the Motor Vehicles Act, 1988. Stop. The court directed the respondent authorities to consider the case of replacement within the next 4 weeks in accordance with the statutory terms and conditions and dispose of the application within the outer limit of 5 weeks. Page 23. The petitioner was allowed to apply for renewal of permit thereafter. Stop. In compliance with the said order, the Secretary, Regional Transport Authority, Howrah, by a letter issued on 21st June 2022, informed the petitioner that the prayer for replacement was allowed subject to placing a new vehicle, subject to placing a new BS6 compliant vehicle, Roman 6, BS6 compliant vehicle. Stop. The petitioner submitted a further representation before the concerned authority on 4th July 2022, requesting the authority to allow him to place BS4 compliant vehicle instead of BS6. BS6. Stop. The said representation is yet to be considered. Paragraph. Learned counsel for the petitioner takes this court to a notification issued by the Government of West Bengal Transport Department on 2nd June 2023, which indicates that if the route is exclusively within the Kolkata metropolitan area, new permit being issued by the STA or by any RTA, the vehicle to be placed in permit may preferably be BS6 emissions norms compliant, but not less than BS4, 6 or 4 Roman, BS4 norms compliant. Stop.
May I point out? Well, your lordship kindly come to page 4 of that notification. This is specific direction is that in respect of the replacement also that your lordship will find. Head notes under the permit, issuance, renewal and replacement. B. There your lordship
Yes.
cross C.
The
That is.
notification also says that replacement of vehicle should be encouraged to be made by higher model vehicle or at least by similar technical specification, including BS norms / age of the existing vehicle. Stop. Paragraph. The petitioner seeks a direction upon the concerned authority to consider his representation in terms of the notification dated 2nd June 2023.
Hello.
Paragraph. Upon consideration of the submission made on behalf of the parties, the writ petition is disposed of, directing the concerned authority being the secretary.
My lord secretary. On a respondent number 4.
Being the 4th respondent herein, to consider and dispose of the representation submitted by the petitioner dated 4th July 2022. Within 6 weeks from the date of communication of this order.
That depends on my lord.
That's why I'm not making it 1 month, let it be 6 weeks. Upon affording reasonable opportunity of hearing to the petitioner and in the light of the notification dated 2nd June 2023, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week there. Disclosed of petition. Petition টা আছে এর মধ্যে। তো দেখে নেবে তাহলে ক্লিয়ার হবে।
Item number 228.
Lord, in this matter, I'm appearing on behalf of the private respondent number 5.
My lord, in this matter, I am appealing for the petitioner, my lord. Your lordship, my lord, last occasion, the
Other respondents, the state.
my lord, private respondents appearing, my lord, this statement, Mr. Shane is appearing. My lord, the last order, my lord, your lordship, on 25th July 2023, was pleased to direct the state to file a report. My lord, I have a talk with Mr. Shane, my lord. My lord, he wants some time for file the report, my lord. Your lordship, kindly give the, my lord, 10 days time to file the report.
Anyone representing the state? Yes. Let the state come back with the.
No, my lord, I have a talk with Mr. Shane, my lord. My lord, he said, my lord, to take, my lord, 10 days time to file the report.
I'm saying exactly, let the state come back with the report.
Yes, my lord, your lordship, kindly fix the date after 10 days.
Learned counsel for the state respondents seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 15th September.
My lord, reply first.
Please serve advance copies.
Item number 229.
So I am for the writ petitioner. My lord, I am filing my exception to the report.
Served.
Yes, my lord, served. Served on Friday, this Friday.
Yeah, I am ready.
Okay, I am also ready. Lordship, this is a matter, Lordship will remember. Lordship, Railways initiated one tender on 31st of May 2023, and a petitioner
31st March, not May.
31st of May, my lord. At page 17, it is there, tender notice. Now, my lord, pursuant to the tender notice, my lord, writ petitioner took part in the tender process, and his bids were emerged as the highest. And accordingly, my lord, as per the e-auction policy, lordship, an e-agreement was executed with the railways. Now, in the said e-agreement, which I have annexed at page 23 of the writ application, it was stated that I have to commence my loading and unloading operation by 5th of July 2023. Now, accordingly, as a precondition to this e-agreement, my lord, I have deposited an earnest money to the tune of 1,08,644. It is there with them. Now, my lord, all on a sudden, my lord, the petitioner received one communication from the railways through railways IRES website that a contract has been cancelled. Now, my lord, immediately thereafter, I made one representation before the appropriate authority asking me what is the reason for such immediate cancellation. Now, my lord, thereafter, during pendency of the said representation, my lord, they floated another tender in respect of the same self-parcel ban, which I have also annexed at page 69 of dated 19th of June 2023, saying that the said tender will be opened on 4th of July 2023. Now, I am challenging the cancellation of my contract and also the floating of fresh tender. Actually, I prefer this writ application. Now, this writ application, my lord, I have filed on the two grounds that after the execution of the contract, my lord, there are certain provisions in the contract agreement, which is overall guided by the Railway Board FM Circular 11 of 2022, saying that there has to be adherence to the notice. I have to be put on notice before railway intends to cancel the contract. Now, my lord, also there are clauses that in case of punitive, if I have breached any terms of the agreement, then they reserve the right to cancel it without giving me any notice. Now, as I have not commenced the operation, my lord, because before commencement, I was terminated by the railways. So there is no possibility that railway could have terminated my contract on the basis of punitive measures. Now, my lord, I have preferred this writ application, my lord. This lordship was pleased to stay the impugned tender notice, calling upon the railways to file a report. The report, my lord, had been filed. Lordship, kindly come to page 3.
Oh, it was, the operation was not commenced?
No, no, no. Operation was not yet commenced. I was told to operate from 5th of July 2023. Before I start my commencement, I received a notice. Not only notice, my lord, it's a SMS through their portal that your contract has been cancelled. Now, my lord, I have deposited the earnest money, and earnest money is still lying with them. Now, after that, the tender was floated. I have challenged that. Now, in the report, my lord, we will find at internal page 3, paragraph 4. Lordship, kindly come to the what the ground they have taken, my lord. That is the, my lord has found, paragraph, page 3, paragraph Roman 4. The fact is that during verification of documents after auto-awarding of the contract, it was found that the petitioner S1 SI Express, Howrah, 3 Nandaghosh Road, Howrah, such and such, has submitted requisite documents, that is audited balance sheet, profit and loss account for the tender ending 31st of March 2021 in the name of Shamim Iqbal Khan, 78 Ilkhan Road, such and such, Howrah, such and such, instead of SI Express, Howrah, which is purely contrary malafide to the extent policy of FM Circular 11 of 2022, wherein it is provisioned that the allotment of the lot shall be cancelled, or if the contract has been executed, the same shall be terminated by forfeiting the EMD security deposit without any further notice. My lord, the railways clause is this, that I have, at the time of execution of the contract, before that, my lord, I have submitted some misleading documents. Those misleading documents, my lord, they have stated that is the main reason such contract has been cancelled. Now, railways power to cancel contract, lordship, will appear at page 41.
Of the writ petition?
Of the writ petition. This is, lordship, at page 51. This is the freight marketing circular 11 of 2020.
Page 51.
41, my lord. 41 of the writ application. Lordship has found?
Yes.
Page 41, clause 1.4. There, it is their main clause. The entity shall be required to upload registered legal documents in its profile in IREPS at the time of registration in IREPS or before participation in auction. Railways reserves the right to verify the documents uploaded in the IREPS profile of the successful bidders at any time. And if any information provided is found to be false, misleading, or the documents uploaded by the entity are found to be false, invalid, then the railway may take appropriate punitive action against the entity, including but not limited to the termination of the award running contract, along with forfeiture of security deposit or cancellation of allotted lots with forfeiture of earnest money without any further notice. Now, this is their ground, my lord, for cancellation of contract. I say, my lord, the proprietorship, I have participated in the tender through my proprietorship firm, that is SI Express Cargo. I am the proprietor. Now, the definition of the proprietorship firm, my lord, proprietorship lordship is aware that proprietorship firm do not have any legal identity of its own. It has to act through the proprietor. It's not a company or it's not a partnership firm, my lord. So it has no legal entity even to maintain a writ application on its own. Now, the definition of the proprietor, my lord, as found as Supreme Court on words and phrases, my lordship, kindly see what is the definition. Lordship, proprietary, lordship has found.
Yes.
Proprietary means of a proprietor that is holding proprietary rights. A proprietor is one who has a legal right or exclusive title to anything. Lordship, kindly mark this thing, my lord. Now, my lord, and also in the concise law dictionary, my lord, will find. Lordship, kindly see. Lordship has found the proprietary and the proprietor.
Yes.
Lordship, proprietary and the proprietor. Proprietary means of a proprietor that is holding a proprietary rights. A proprietor is one who has the legal right or exclusive title to anything. It is synonymous with the owner.
Yes.
Now, my lord, in the exception, my lord, I have annexed all the documents which I have submitted before the railways before taking part in the tender. Lordship, I'm coming one after another. These are the documents are there with the railways. Now, Lordship, kindly come to exception. This is the certificate of enlistment at page 10 of my exception. Their main ground is that I have submitted misleading documents. And as per clause 1.4, they have a power to terminate. This is their main ground. I'm only meeting that allegation, my lord.
Particularly, they say it's in the name of some other person.
They say that it should have been in the name of the proprietorship firm, but all the documents you have loaded is in the name of you, the proprietor. And my case is this: the proprietor has the legal entity, proprietorship firm do not have the legal entity. And all the documents I have indicated and which I have placed before the railways before taking part, Lordship, they have kindly see what are the documents. And they have not said that I am not the proprietor of this firm. Page 10, my lord. This is the license department, certificate of enlistment. Kindly see in the left, in the top, SI Express, and just after the name of the proprietor is this Salim Iqbal Khan. This is the writ petitioner. Next, my lord, kindly come to page 11. That is the auditor's report. This is the auditor's report which says that we have audited the attached balance sheets of Salim Iqbal Khan of the Purva Bahala East Midnapur as on 31st March balance sheet and the profit and loss account for the year.
Proprietorship firm has to be in the name of the proprietor.
Yes. And now, my lord, kindly see the most important and vital document. Registration with the railways. This will, lordship, kindly come at page 17. Page 17 of my exception.
Yes.
Kindly see, this is the registration, my lord. Before I took part in any tender, this is the utmost requirement that I have to be registered. Kindly see, name of the firm is SI Express Howrah. And kindly see.
Where is your name in this registration?
Subsequently, my lord. Next page. Samim Iqbal Khan. Trade name, and then it's SI Express. And then there are the continuing documents. I have to register with the Indian Railways through my proprietorship firm that is there. And I am the proprietor that is also there. Lordship will find from page 23. These are the contracts which I have executed with the railways on the basis of these documents, and the tender issuing authority who has cancelled my contract has issued these tenders, and these are the running contracts which are at present I am operating with the railways, from the railways. Now, you kindly see the contract agreement. This is SI Express Howrah, and kindly come to page 23, 25, my lord. Kindly see the executing authority and the name of the proprietor. Signed by Samim Iqbal Khan from page 25, bottom, my lord. And signed by Rajesh Kumar, that is the auction authority, senior DCM KJP. And also, another contract which I have executed with the railways, also with the same proprietorship firm, SI Express Howrah. And again, my lord, at page 28, Samim Iqbal Khan, signed on 23rd of February 2023 and signed by the senior DCM authority. So these are the documents, lordship, I have submitted here also. These were the documents on the basis of which the railways have granted me 2 contracts which I am operating at present. And these are the documents which I have submitted before them, before the auction. And they are, apart from this particular clause 1.4, they have said that I have deposited misleading documents. These cannot be termed as misleading documents. These are all current documents. These are there with the railways, and as per the railway rules, whatever documents is required from my end, my lord, I have submitted all those things. And when they have acted upon these documents by awarding me contract in respect of other trains of the same zonal authority, then they should not have cancelled my contract on the basis of these statements. I made a prayer, my lord, directing my lordship as seeking a prayer of mandamus upon them to cancel the tender and award me the contract, because already on the basis of these documents I am running the contracts, my lord. This is my prayer.
Let us hear the evidence.
And my lord, only one aspect, my lord, they have not annexed any documents. In the report, lordship will find, except two averments, my lord, on this issue, not a single document has been annexed in support of their contention. Let them say that it is a misleading and false, because they have signed.
Page 2 of my report.
Yes.
Page 2, para 1. A tender was floated through the auction for parcel at 24 ton capacity by train that through auction. I tender notice bearing number this 31 on round trip basis. Same contract was awarded to SI Express, Howrah, the non-reverse Howrah 1 as highest bidder of the subsequently, madam, an agreement was executed between CDCM and Shami Mikbar for the period 2 years commencing from madam 5/7/2023 as per their bidding based before signing the contract. Same contract was decided to be cancelled due to some technical. I'm coming that thing. Petitioner was informed through SMS in his mobile on 19/6/2023 of 3 days from midnight of execution of contract that the state contract was terminated as per railway guidelines contract under para 72 standard condition of contract. They will kindly come to Malak that condition, Malak. That is page Malak 48. Page 48, para 72.
Yes.
By railway or the administration, railway have the right to terminate the contract agreement without any financial repercussion on their
On either side.
On either side for any reason, whatsoever, after serving 1 month of notice to the contract. That has not been done.
No. 1 month notice has not been given.
Railway shall also reserve the right to terminate the contract with immediate effect without any financial repercussion on either side in case of operational exigencies of in case of what the asset for which the contract was awarded. And then is not available for commercial exploitation due to some other development or change inside of any other reason. Full EMD and ASD of lump sum freight license fee paid by the contractor shall be refunded to the contractor without any interest. That is a condition.
So you have not taken any of these issues in your letter.
Well, according to your lordship, second paragraph, immediately
For any reason whatsoever after serving 1 month's notice to the contractor.
Yes,
Where is the 1 month's notice? 17.2 as you're relying upon?
your lordship, come to that 72 under standard condition contract.
17.2?
Yes.
Yes, there is a provision for 1 month's notice.
Come to our next permission.
So no notice was served admittedly. Please come one by one. There was no notice.
This act is concerned, permission has been done, but
No notice was issued.
procedure,
Was there any notice issued as required under 17.2 on which you are relying upon?
Then according to my instruction, some SMS and also some telephonic notice has been served. But as far as postal receipt concerned, that is not done.
You have to show service of 1 month's notice. 17.2 mandates service of notice.
Instruction, madam, that SMS has been done, madam.
Is SMS an accepted mode of service?
Now, madam,
Page 26.
Please show me the provision under which you have served by SMS. It's an authority, it's not a next door neighbor that you just send an SMS.
Knowledge, madam.
Not relevant.
That is his knowledge.
That is after the termination, it is.
That I have no knowledge.
That is after termination, it is within his knowledge.
Yes.
Prior to termination, a 1 month's notice was required. Where is that notice? You are reading 17.2, isn't it? Please read 17.2, page 48.
And then, madam, Hiroshi Kaji come to madam. Para 4 has already been. And then, madam, Hiroshi Kaji come to madam. Para 6, madam, railway was statutory part of Government of India. Hiroshi Kaji come to page 4, para 6, madam. Railway is statutory part of Government of India and never acted illegally or arbitrarily.
This is immaterial. Please do not read this paragraph. Please show me that notice was served.
Notice, madam, according to madam, that telephonic,
Where is it stated that telephonic notice? Show me. Where is telephonic notice service? Please show me. That prior to termination, 30 days telephonic notice was served. Please show me that also if you can. This is a railway authority, sir. It's most unfortunate.
No.
Opposition.
No, my lord. They cannot.
All the papers, madam.
Mr. Roy, when the court speaks for you, please. Yes. Your instructions are neither here nor there.
To me, madam,
You are relying upon 17.2. Yes? You have read out 17.2. Have you seen the last line of 17.2?
I saw that. But
So where is the
Here
notice?
also, madam.
Yes.
They have said that.
And they have said that no notice was served.
Telephonic, SMS has been done, madam.
Telephonic SMS, you have stated in your report. That is after the termination. I am asking about before termination.
That actually what happened, madam, some amicable solution has been sorted out by side and also relevant at first. Heading this, madam, that amicable has been done.
Where are the submissions in your report? Amicable solution and all that? You cannot mention anything from the air, isn't it?
That is report also.
Yes, so that should be substantiated by documents. You are supposed to be a central government authority. I repeat, you are not the next door neighbor of the petitioner. That you go to his house, sit in his drawing room, have a cup of tea and have an amicable settlement. This is a central government authority.
Has to be done, madam, because of some process has been restricted, madam.
What process, what something? Let me pass an order.
My lord, on the basis of these documents, they have awarded contract.
You want to make more submissions?
No. No, you kindly direct them to award me the contract. At least allow me to operate the parcel space.
Let them reconsider.
Lordship, may I say one thing, my lord? They don't have any further ground. Only ground which they have taken, Lordship, have substantiated. I am operating on the basis of those documents by them. Now, they have not come up with any other grounds. So, on the basis of this, my lord, they have no reason to terminate my contract. They have not adhered to those provisions. Now, my lord, let them at least continue with the contract.
Take the order.
Let-
Exception used by the petitioner to the report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph, her learned counsels for the parties. The petitioner is aggrieved by termination of the contract by the respondents even before the petitioner commenced operation in terms thereof. Stop. upon the petitioner being the highest bidder and depositing security amount to the tune of rupees 108644, the contract was executed for a period of 2 years, commencing from 5th July 2023. Stop. The petitioner received a message from the respondents. This is the message that you are talking about.
Yes, my lord, 26.
On 16th June 2023, stating that the contract had been cancelled by the authority. Stop. A fresh tender notice was published by the authority in respect of the same parcel van on 19th June 2023. Parcel van on 19th June 2023. Stop. Paragraph. Learned counsel for the petitioner submits that the contract was terminated without giving the petitioner an opportunity of being heard in terms of clause 17.2 of the freight marketing circular number 11 of 2022. Stop. The respondents have alleged that policy of the freight marketing circular 11 of 2022. Stop. The petitioner takes this quote to the definition of proprietorship definition of proprietary, T-A-R-Y, proprietary, as laid down in Supreme Court on Words and Phases. Inverted comma. Supreme Court on Words and Phases by Justice R.P. Sethi, which says that a proprietor is one who has the legal right or exclusive title to anything. Stop. It is synonymous with the owner. Stop. According to the petitioner, comma.
May I leave my?
The petitioner is the proprietor of the proprietorship firm SI Express and Where are your documents? It's with the, in the exception.
Exception, my lord, it starts from page 10. All I have, these are the documents which are there with the railways also. Whatever documents they require, I have submitted. And most important is that of the registration.
And all the relevant documents, including registration is at page 17.
Page 17, 18. Then GSTI and account which I have there with the
Including the
railways.
registration certificate of the firm, names the petitioner, Shamim Iqbal Khan, as the proprietor of the firm. Stop. Therefore, the question of filing false or misleading documents before the authority does not arise. Paragraph. In refuting the contention of the petitioner, comma, learned counsel for the respondents submits that the contract was terminated in terms of clause 17.2 of the Freight Marketing Circular 12 of 2022, since the documents filed by the petitioner were found to be contrary to the policy. Paragraph. The documents submitted on behalf of the petitioner unanimously demonstrate that the petitioner is the proprietor of SI Express, which is a proprietary firm, and such fact has also not been denied or disputed by the respondents. Stop. The respondents have placed reliance on clause 17.2 of the Freight Marketing Circular 11 of 2022, which mandates service of 1 month's notice prior to termination of a contract/agreement by the railway administration. Stop. The respondents have failed to produce a scrap of paper to demonstrate that such notice was issued upon the petitioner in terms of the circular. The report in the form of affidavit submitted on behalf of the respondents is also silent as to on what basis the documents submitted by the petitioner were held to be false misleading, or malafide. Stop. In fact, the documents appended to the exception submitted by the petitioner prima facie do not suggest any malafide practiced by the petitioner or any dispute with regard to the identity of the petitioner. Stop. There is no termination letter in writing.
Termination only page 26, that is the SMS, my lord. Page 26. Apart from that, there is nothing else.
Page 26 of your exception.
No, my lord, writ application.
Page 26.
Page 26, my lord, the second paragraph. Second message, contract number such and such cancelled by Kharagpur division, 16 June. This is the only intimation I have received. And Roshi will kindly also indicate, my lord, by the railway authority. It's not denied by him. And also the documents were the basis of further awardment of 2 contracts, which I am at present operating under them.
These separate columns.
No. These were the tender issuing authority. Lordship,
Is that part of your record?
Yes. I have annexed that.
In the writ petition?
In the exception, I have annexed. These are the contracts which I am operating under them, and the
On the
documents.
basis of the same documents.
So all are same, my lord. Tender issuing authorities are same.
It also transpires from the documents annexed to the exception that the petitioner has been operating in respect of 2 other contracts under the railway authority, with the railway authority, with the railway authority on the anvil of the same documents as used by him in connection with the present contract. That is your submission.
Yes, ma'am. And it has not been denied, cannot be denied by him also.
Paragraph. Besides the one SMS sent by the railway authority stating that the contract has been cancelled by the Kharagpur division -commercial, no other communication was admittedly made to the petitioner prior to or even after cancellation of the contract, after termination of the contract. Stop. A fresh tender has been floated by the authority with regard to the same parcel van on
19th June. And to be opened on 4th July, which was stayed by your lordship.
19th June 2023. Stop. Paragraph, upon consideration of the submission made on behalf of the parties and material on record, this court is inclined to hold that since the contract of the petitioner has been terminated by the railway authorities without service of notice upon him, comma, the termination order falls foul of clause 17.2 of the Freight Marketing Circular number 12 of 2022. Stop. Also, comma, the respondents have failed to substantiate such termination in accordance with clause 1.4 of the circular. Stop. The order of termination, comma, order of termination, comma, Devana, having been passed in violation of the rules in place, comma, is therefore set aside slash quashed. Paragraph, as a consequence, the tender notice issued by the authority on 19th June 2023 is also set aside slash quashed. Paragraph, the concerned authority being
Senior division.
the fourth respondent?
Yes, ma'am.
Being the fourth respondent here in comma, is directed to revisit the issue in the light of the observation made in the body of this order and consider resumption of the contract in favor of the petitioner within 2 months.
Well, within 4 weeks, my lord. Because the parcel van is running empty and they are losing the freight.
6 weeks.
6 weeks.
Within 6 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, comma, in accordance with law.
Grateful, my lord.
Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof.
Grateful.
Disposed of.
Highly up.
Next.
Actually, the books, can we take back?
Yes.
The books,
Yes, yes, sure. বইগুলো ফেরত দিন। Hearing time.
Right.
Yes, may it please the lordship. I am, my lord, aggrieved by the refusal of the railways to grant me concession.
Again, railways.
But in
You're
this matter, yes, sir, and I'm appearing.
Affidavits are complete?
Yes, yes.
Affidavits have been exchanged long back, but just now I have received copy of the affidavit from the department. And when it appears from your lordship, there are 2 CAN applications. CAN number 2 and 3.
I believe, my lord, CAN 2 and 3 have been both disposed of, though they are appearing in my lord.
It is all right.
Subject to correction, because we are also, even my learned advocate was changed brief.
4 was a restoration application.
Yes, it has been restored.
What is 2?
2, 3.
Well, my lord, kindly give me, my lord, at least 1 week time to get ready in this matter. Just now I have received the copy.
Let him come.
I cannot, my lord, stand in the way.
Also grateful to your lordship and also want to have obliged to my lord. No.
Prayer of the- On prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 15th September.
Grateful to your lordship. Grateful.
My lord, I know that is my lord's usual practice, but may it retain its position.
Hopefully it will retain, because group 7 matters are not many.
Yes.
Much obliged.
Item number 241.
Thank you.
Respondents? Yes. You're ready? Why don't you take these chances when your senior is not there? Switch on the microphone, please. Please speak into the mic. Switch it on, please. Yes.
My lord, my senior is absent. Actually, he is suffering from fever.
Why don't you make your submission? Not seen the brief at all. You don't know how it looks. These are opportunities, madam. When your senior is not there, you can make a few lines submission before the court. The court is there to help you, isn't it? Please be ready on the next occasion. I'll remember this case. There are other respondents also. 6 and 7.
Main respondent is the Union of India.
6 and 7. Mr. D.N. Roy, Mr. Rajesh Kumar.
Yes,
they are all appearing. Salt Commissioner, Assistant
Yes,
Salt
Salt
Commissioner.
Commissioner, all are there.
8 is a private respondent, I think.
This is, my lord, though the rebate, I will get the rebate or not. There is a judgment of Justice Sabyasachi Banerjee, Sabyasachi Bhattacharya is against me. My lord, I will place, my lord, that is sub silence, so because the Supreme Court judgment has not been considered, not been placed before his
So
lords.
you had mentioned this earlier also. But today bad luck, I think.
If I can cross that hurdle, then I have.
Affidavits are over.
Yes.
Come back some other day. Okay. On prayer of respondent numbers 1 to 5, the matter is adjourned. তার আগে করুন, none appears for respondent numbers 6, 7 and 8. Paragraph, let the matter appear under the same heading on 12th September.
Yes, কি বার পড়ছে?
Tuesday, Tuesdays and Fridays. 12th September.
Item number 242.
My lord, I am appearing through virtual mode, my lord. I pray for 1 week time, my lord.
For what?
My lord, I am not well today, my lord.
Oh. No, affidavits are complete.
My lord, everything is complete. Affidavit, rejoinder, everything is complete, my lord.
It's appearing.
I'm appearing.
Mr. Debra is appearing. The petitioner asks for time. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 15th September.
Grateful.
May I please your lordship?
I am appearing for this report, my lord. Today, I got the affidavit opposition.
Immediately reply.
Reply.
Today you serve.
Today, I have to go through this.
Today, no.
আজকে না কালকে সার্ভিস করেছি কালকে সার্ভিস কালকে সার্ভিস হয়েছে
Where is the opposition?
কালকে সার্ভিস হয়েছে
Not filed. Have you filed the reply? Oh, all today?
This is the date I think. I have served yesterday.
Served little earlier.
I have served yesterday.
Affidavit in opposition.
This is my
Affidavit in opposition submitted on behalf of respondents and affidavit in reply submitted on behalf of the petitioner are taken on record. Paragraph on prayer of the state respondents, the matter is adjourned. Paragraph
Time
in the
limit.
matter appear under the same heading on
করে নিন
19th September.
My lord. দুইটা এক গাদা করে লিখিস প্রবলেম হয়ে যাবে
44 also, my lord.
এখানে 244 244
Same.
Here no affidavit has been expressed.
so one matter to covering two
No affidavit.
both the matter covered my lord. Matter covered only
There's a
simply
difference
action
of affidavit.
simply
No
action
affidavit.
So I'll record if you don't want to find
Mr. Nayak is there.
That is to there.
That is point is same identical issue Mr. Nayak is there
But it's under the under hearing heading.
on a hearing let it be
Direction is there for
let it be
affidavits.
tagged with my lord this matter that is better
Same issue.
same issue two big
Only route is different.
What is divided by issue same BS3 BS4 now we asking for BS3 after several notifications public he stand in the own BS3
By consent of the parties, same date.
Same date.
ওই 19 September একসঙ্গে দুটো
By consent of the parties, comma, let the matter appear under the same heading on same date. Being
I will also kindly note that no affidavit has been filed.
আর দরকার নেই
And his statement may be reported.
আমার চাই
আগে করুন একটা line.
Sorry.
It is submitted on behalf of the respondents that the affidavit in opposition used in WPA 19833 of 2022 shall cover the present petition. Shall be applicable for the present. Shall be applicable in the present petition. Therefore, by consent.
this matter can tag with that matter that is better
They'll appear one by one. Let us see.
Item number 245.
But in the earlier occasion, one matter on the self-same issue was directed by your lordship to appear along with this matter on 29th August. But
245.
no, but that has been directed to be appeared on 29th September, my lord.
Which matter?
And another matter, mother, that was tagged with this matter, my lord.
Which matter? This matter means.
Sumita Samanto.
ও হ্যাঁ ওটার সঙ্গে হয়ে যাবে
But that has been
আইডেন্টিক্যাল ইস্যু লর্ডশিপ
But that-
Which matter? 245.
243. 243, 244.
244 along with
But in the order sheet, I mean, that matter has been appearing, has been directed to appear on 29th September, my lord.
হোক না ওই যে এই অর্ডারটা যে হবে তো সেটাই গভর্ন করবে
It will be guided by that rules. If an order is passed in this matter,
আর ওটা
it
আর টেনে না
automatically cover the other.
অটোমেটিক্যালি ওটা কভার হয়ে যাবে শুধু একটাই বিএস3 বিএস4 তোরও যে বিএস3 তে দিবি না
Total replacement.
বিএস3 যা স্যামই সে
Total replacement.
বিএস3
And Mr. Bhattacharya is not seeking extension of the interim orders. You don't require.
No interim order, my lord.
Which matter?
there is no interim order
The earlier matter I saw an interim order.
other matter also there
And my interim order was passed till the disposal of the matter.
245.
for the
Yes.
for the Union of India. না হবে না
Affidavits exchange.
Yes, my lord. Affidavit exchange, my lord. So final hearing. So this is the matter.
But your lordship kindly extend the interim order for a limited period and fix the matter in the next month.
My lord, kindly appreciate one thing, my lord. When it comes,
There is interim order.
I have no difficulty. Only thing is this, I want to do this matter, my lord.
I understand. I'm back, sir.
Lordship, interim order is expiring on 31st of August.
I'll extend it for another month.
Another month and
But the Union of India.
Union of India.
Union of India, the matter is adjourned. Paragraph. The interim order, let the matter appear under the same heading on 26th September.
Prior to that, 19th.
19th.
Lordship.
Yes, 19th September. Huh? Paragraph, the interim order till after vacation.
No, Lordship.
But till 30th, it will not be completed.
Yes, my lord.
So,
It will be completed on 19th.
I want to complete today, my lord. They are taking the
19th,
time.
19th, I'll complete, my lord.
that is. The interim order granted earlier is extended till 30th September or until further orders, comma, whichever is urgent.
Lordship.
For the repetition, my lord.
19th.
19.
246.
Lordship, I am for the pleadings are complete, my lord.
My lord, I am for the Union of India. Senior has not come, my lord, today.
My lord, interim order is till 31st of August, my lord. Lordship, kindly fix any date or let it written in lordship's list.
Any date.
Lordship fixes any date subject to lordship. This is a matter, lordship, of cycle.
So specific interim order in this matter.
Yes, yes, yes. Interim order is there. The lordship has
Any
stated.
action taken by the respondent
No, no, no.
authorities?
No, no, prior to that, my lord.
By the result of
Prior to that, prior to that.
Please tell me the date.
Yes, yes. Lordship, this is one of the indications. Another order copy is there.
19835.
এটা অন্য ম্যাটারে দিচ্ছি।
এটা কত?
It's 22.
Yes, my 22. Sorry, my lord. Kindly, this is the.
না না আইটেম এটা তো
এটা কি দিলেন?
22,965
এটা কি
এটাই তো
দিলেন
তাই।
আপনি? 246 দেবেন তো।
Lordship, this is there.
So I had given a wrong.
Yes, this order is also there, my lord. Lordship, they have withdrawn the.
Just give me a minute.
22,965
22965.
Yes, 2296.
Item 246.
This is the parent interim order.
I'll just find out the file is not.
So I'm filing my reply, my lord. And this was lordship's interim order on 9th of.
Yes, it's there. The file was wrong.
Lordship, kindly fix any date, lordship, by extending the interim order, let the matter be disposed of by that day.
Affidavit in reply submitted on behalf of the petitioner is taken on record. Paragraph on prayer of the respondents.
Opposition
Prayer
file
of
করে
the
দিয়েছেন?
Union of India, the matter is adjourned. Paragraph, let the matter appear under the same heading on 26th September. Paragraph 26. Paragraph, the interim order granted earlier is extended till 20th November or until further orders, comma, whichever is earlier. Shall I call matters from the supplementary list? রাখুন দেখি। রাখুন monthly list.
Item number 1216.
I am for the writ petitioner, my lord. On my other side, my lord, Mr. Shonojit Kumar Ghosh is appearing for the Eastern. 1216. Sharon.
Possibly my learned.
Sorry, my lord. Mistake.
I am for the petitioner.
Yes. Affidavit-
Petitioners have applying their vehicle.
Affidavit 16.
Yes, ma'am. In route number 71, Howrah Moidan to Mohishbathar. But they have approached to the Regional Transport Authority Kolkata for curtailment of route from Howrah Moidan to Rajabajar. 50% of the buses of the route rotational basis. But that has been granted and sanctioned. If your lordship kindly turn up to page 25 of the writ petition.
Yes.
But this is a communication of 12th of May 2011 by the Secretary Regional Transport Authority addressing to the Secretary route number 71, that is my client. RTA Kolkata in the meeting dated 5th of May 2011 accepted his proposal dated 14th of February 2011 for diversion of buses in the route on rotational basis from Howrah Moidan to Rajabajar instead of Howrah Moidan to Mohishbathar. The initial route was Howrah Moidan to Mohishbathar, that has been curtailed, and now it has been given to Howrah Moidan to Rajabajar, subject to the approval of the Transport Department and in the interest of the general market. This second part of the order, subject to the approval of the state government, is under challenge. Then you will also kindly turn up to page 28 of my writ petition. That is annexure P6, a communication of dated 15th of July 2011.
Yes.
RTA board meeting resolution has been adopted. Kindly see Regional Transport Authority Kolkata in their meeting dated 14th of July 2011 has accepted his request by letter dated so and so for allowing flying 50% of the buses of this route on rotational basis from Howrah Moidan to Rajabajar.
Page 27.
This is page 28.
58.
I am reading again, my lord. This is the letter of my lord 15th of July 2011 issued by the Secretary Regional Transport Authority Kolkata addressing to the Secretary Regional Transport Authority Kolkata, my lord. To the Secretary Route Committee, route number 71. Regional Transport Authority Kolkata in the meeting dated 14th of July 2011 has accepted his request by letter dated 22nd of December 2010 for allowing flying of 50% of buses of this route on rotational basis from Howrah Moidan to Rajabajar. Post facto approval in the support of this decision of Regional Transport Authority Kolkata will be taken from the government in transport department. Again, my lord, that same rider has been given. But then your lordship kindly come to the next page. That permit has been modified. If you lordship kindly see one of the permit at page 29. See the route alignment, middle portion. Howrah Moidan to Salt Lake City via Shialda flyover Rajabajar. So previously it was up to Mohishbathar. Now it has been curtailed to my lord from Howrah Moidan to Rajabajar, Mullik Bajar, so and so, and Salt Lake City. That is the, then now you'll also kindly come to the bottom portion. Allowed to fly 50% of the total strength from Howrah Moidan to Rajabajar on rotational basis as per board meeting dated 14 July 2011 and subject to the post facto approval of the Transport Department, Government of West Bengal. But I have annexed number of permits. The all says, well, kindly turn up to page 31, the same condition. This is another permit of the writ petitioners. The same thing has been subject to the post facto approval. Well, this post facto approval, whether required or not, this is under challenge before your lordship, my lord. Your lordship knows, my lord, I have very little knowledge so far this part of the this subject is concerned. Your lordship kindly, your lordship has the book, my lord.
Yes.
But kindly come to my lord section 68.
of the Motor Vehicles Act 1988.
Yes.
Well, this is kindly see the power, general permission as to application for, sorry, my lord, 68. Well, transport authorities, my lord, formation of transport authority, lordship knows, even that, my lord, for my satisfaction, I'm reading 68(1). The state government shall by notification in the official gazette constitute for the state a state transport authority to exercise and discharge the powers and functions specified in section subsection 3, and shall in like manner constitute regional transport authorities to exercise and discharge throughout such areas in this chapter referred to as regions, as may be specified in the notification in respect of the each regional transport authority, the powers of the functions conferred by or under the chapter on so and so. So the power has been vested to the state government to form the transport authorities, which means regional transport authority or state transport authorities. Now, your lordship, kindly come to section 72. Well, prior to that, your lordship knows, my application made under section 70, application for stage carriage permit, there is no doubt. Kindly turn up to section 72.
Yes.
Grant of stage carriage permit. Subject to the provision of section 71, regional transport authority may, on an application made to it under section 70, grant a stage carriage permit in accordance with the application or with the modification as it deems fit, or refuse to grant such order. So our power vested to the regional transport authorities to grant permit on the basis of the application to be submitted under section 70 of the Act. Now, your lordship, kindly see, come to page subsection 3 of section 80. So far the curtailment or extension of route is concerned, subsection 3 of section 80. What I'm reading, subsection 3. An application to vary the condition or any permit other than a temporary permit by the inclusion of a new route or routes or a new area, or by altering the route or area covered by it, or in the case of stage carriage permit, by increasing the number of route trips above the specified maximum, or by this variation, extension or curtailment of the route or routes or the area specified in this permit shall be treated as an application for the grant of a new permit. Then provided further, the first proviso I am reading, second proviso, in the case of variation of terminal shall not be altered, and the distance covered so and so. In the case of extension, so and so distance. So my specific case is that none of these sections says that either grant or curtailment of route, there is any need to obtain any prior approval or subsequent post facto approval from the state government. This is my only case, my lord. Subject to the condition or approval of the state that has been written, that is, there is no such provision. Statute does not permit. State transport authority, even regional transport authorities, are entirely empowered either to grant permit, curtailment of permit, or extended permit. This stigma, rather the rider, I am challenging before your lordship.
That's all.
That's all.
Yes, Mr. Rebra. Where is the provision?
There is no provision as per lordship. Turn to page 26.
Of the writ petition? Yes.
That is issued by the Joint Secretary to the Government of West Bengal Transport Department. Whereas, my lord, in writing reference to memo number 12, in the matter of comprehension, I have directly written that as per notification number 12, the group number under Howrah region as well as we are requested to send proposal. Pursuant to that, my lord, proposal has been sent by the RTA Kolkata, and subsequently, I think, my lord, it was approved. In the case, my lord, post facto approval, there is no provision.
There is no provision for approval also, because the RTA and the STA are authorized.
Independent bodies.
Independent bodies who can issue permits, who can allow diversion, everything. So why is separate?
No question of approval from the higher authority. There is independent body, purely independent under section 68, just the referred by the star.
Autonomous.
There is independent autonomous body. There is no for referring the proposal does not and cannot arise.
So let there be an order to that effect.
Subsequently, direct.
Word learned counsels for the parties. The petitioners assail the decision taken by the Secretary, Regional Transport Authority, Kolkata Region for obtaining approval / post facto approval of the Transport Department for permitting diversion of buses in the route on rotational basis from Howrah Moidan to Raja Bazar instead of Howrah Moidan to Mohishbathan. Stop. The paragraph. The petitioners applied for such diversion No. The petitioners are operators in route number 71 from Howrah Moidan to Mohishbathan. Stop. Mohishbathan, comma. Major portion of the route lying within the domain of the Regional Transport Authority, comma, Kolkata. Stop. The petitioners applied for diversion of route from Howrah Moidan to Raja Bazar instead of the existing route from Howrah Moidan to Mohishbathan, which was accepted by the Secretary, Regional Transport Authority in its meeting held on 5th May 2011, subject to approval of the Transport Department. Stop. Proposal of the petitioners for permission to ply 50% buses of the route on rotational basis from Howrah Moidan to Raja Bazar was also approved, was also accepted, subject to post facto approval of the Transport Department. Stop. Paragraph. Learned counsel for the petitioners has taken this quote to section 68 of the Motor Vehicles Act 1988, which envisages that the state government shall by notification in the official gazette, comma, constitute for the state a state transport authority to exercise and discharge the powers and functions specified in subsection 3 bracketed, and shall in like manner constitute regional transport authorities to exercise and discharge throughout such areas as may be specified in the notification in respect of each regional transport authority. authority, the powers and functions, চলছে, the powers and functions conferred by or under this chapter on such authorities. Learned Counsel also places reliance on the provisions laid down under section 72 of the Act, which deals with grant of stage carriage permit, as well as section 72, 68 কিন্তু আগেরটা। This is reliance on section 72 বলেছিলাম না? 68 and section 72 এটা দরকার নেই। ওটা 72 হবে। না 6 তারপরে 72 হবে 72 হুম section 80 within bracket 3 with regard to variation of conditions of permit by the inclusion of a new route or routes or a new area, or by altering the route or routes or area covered by it. Stop. According to Learned Counsel, since the State Transport Authority and the regional transport authorities have been vested with the power to deal with the proposals of the petitioners, approval or post facto approval of the Transport Department is not required for accepting such proposal. Paragraph. Section 68 of the Act of 1988 empowers the regional transport authorities to deal with issuance of permits and alteration of routes as independent authorities, and there is no provision under the law which requires approval / post facto approval of the Transport Department in this regard. Stop. Legal sanction to such approval / post facto approval has not been substantiated by the respondents. Paragraph. Upon consideration of the submission made on behalf of the parties, as well as the law on the point, this court is inclined to hold that the portions of the letters accepting the proposal of the petitioners for diversion of the route from Howrah Moidan to Rajabajar instead of Howrah Moidan to Mohishbathan. Seeking approval of the Transport Department is rehorse the law and is required to be expunged. Stop. Paragraph, the writ petition is accordingly disposed of, directing the concerned authority being the secretary. Secretary should be the authority, being the
Secretary?
respondent number 3, being the third respondent here in comma, to accept the proposal of the petitioners in terms of the
Page 25,
resolution,
board meeting dated 5th of May 20.
resolutions taken in its meeting dated 5th May 2011. There's another date also, isn't it? Or is that the only date?
Yes, that I'm giving.
Page 28.
14 July, another date is page 28.
Yes.
And 14 July
And 14 July
2011.
2011. Line to have resolutions. Line
Two meeting,
to-
ma'am. 5th May and 14 July.
As communicated, vide letters issued on 12th May
May.
2011 and 15th
July.
2011 respectively. Within 1 month?
14 July.
Within 1 month from the date of communication of this order.
Or may I pay one indulgence? I have filed an application can number 4
For what?
for considering my representation for 100%. Let they be considered, only consideration, my lord. That is at annexure can number 4. You will actually kindly come to annexure page, my lord, 19 of can number 4. Can number 4.
This is a different cause of action altogether.
I am praying for 100%. Now I am praying for 100%. If they let them consider, because
This law rescind the
50% I have 50% roster basis is going on. Let them reject it, my lord, because this is also for the main for the.
prayer in the can, and this has no connection with the writ petition.
Prayer there is not so.
Your writ petition is.
That
of
is not happily drafted. I have seen, my lord. This is not happily drafted, my lord. Nee.
How is it connected to your writ petition? How is it related? Yes.
There is no such. Representation is there, but no prayer.
And the prayers are not connected to the writ. It has no nexus.
Connected prayers D, my lord, prayer C. The petitioner be allowed to continue to ply their vehicle in respect of route number 7 as.
Consider that has been approved already.
That is,
So that's
so
over.
but 50%, 100% that has not been recorded.
I have recorded.
What I'm saying, my lord, now they have allowed me 50% of the buses to be allowed on roster basis.
That's also recorded. The second
That
letter.
has been recorded. The
Yes.
subsequent pair has been made instead of 50%, 100% route buses.
There is no
Because
prayer.
there is no pair, but representation is
It is
there.
not part of the writ petition also. It cannot be an independent prayer. is
I'm
it?
leaving to your lordship.
I'll reject this.
I'm leaving.
Or you'll not press. I have to dismiss.
Liberty to.
That's a fresh cause of action.
You'll also kindly make disposed of this application. And if the petitioner is so advised, he may make further application or repetition. This is a fresh cause of action. You'll also kindly record this. That will be better for. So far 100% is concerned. Or without making any comments, you will also kindly dispose of the application.
Not press this. I have to record that, I have to
As a-
dismiss it. That will not inure to your favor later on. The state will take this for
No, I'm leaving to your lordship.
can 4 of 2022 আপনি শুরুতে করবেন এটা the application.
Registration not that.
1311. Oh, it's not in the list also.
Not in the list. Very
Treated as a base list. By consent of the parties, can 4 of 2022 is
The party-
treated as a base list. 4 of 2022 is treated as a base list.
There is an addition of parties. He appears on.
Never appeared.
Never appears. What you can do is
Disposed of also.
So ওইটার সাথে করুন
All the applications collected applications are disposed.
original file, there is no addition of party.
Can number 3.
Connected applications, if any other.
My lord, all connected. My lord. All connected applications.
এটা not press করুন, হ্যাঁ ওইখানে হ্যাঁ যেখানে disposed of হলো রিপিটিশনটা ওখানে রেশাল হয় disposed of no rest costs or urgent certified but everything আছে এটা hearing matter ওখানে connected applications if any are disposed of
I'm getting.
আর সেই ফোরটা একদম শুরুতে করবেন রিপিটিশনের আগে করবেন এটা is taken up is treated as a raised list paragraph করুন the application is not pressed by the petitioners and is therefore dismissed for non-prosecution.
I'm getting. All pending applications disposed of.
Or Dr.
The provision of terms of the and communicated later